Mr. O'Sullivan, if we could now turn to your page 11, please switch on your mics, both of them, the microphones. Thank you. We are now at your page 11, at item 1.4, and you have headed this Major General Feroz Khan.
Yes.
You deal with that over the next 2 pages. So if you could highlight for the commissioners the key aspects of this subtopic.
Yeah, if I can suggest that we start with Annexure M.
That will be page 216?
Page 216.
Yes.
Annexure M, Commissioners, is an email that I sent to the then Commissioner of Police, Commissioner Sitoli. Kekla Sitoli was the Commissioner of Police in May 2021. And I copied Lieutenant General Lebea, who at that stage was the head of DPCI. And my email references a tip-off that we had received at Forensics for Justice. So just to be clear, Forensics for Justice has an online tip-off portal, and it also has a telephonic tip-off portal. So people can phone anonymously, and the number is 0800 118 118. And we occasionally get these messages through. And a message came through, and it was a demand to speak to me. And I phoned the person back, and he insisted on providing this information. So what we do, we often get tip-offs, and the information doesn't check out. It doesn't look like something that's genuine. Or sometimes what happens is you'll get a captain who's in dispute with a general, or a colonel who's in dispute with a general, and they'll make spurious complaints. And when we get these tip-offs, before we do anything, we look at the background of it to see if there is anything there. Otherwise, what might be happening is we might be aiding and abetting malicious tip-offs against senior officers. But when we received this tip-off, I met with the person concerned, and the information that was given on the tip-off is listed there. And I'll just read it out quickly on page 216. 1, is involved in facilitating drug trafficking with Nassif Modak of the Western Cape. Well, we know that Nassif Modak of the Western Cape is now in prison. 2, is involved in chop shops and the selling of the products thereof. And now chop shop is a colloquial term meaning places where you dismantle stolen cars into component parts and sell the component parts. He's involved in money laundering for criminals in the underworld. 4, he protects certain criminals, notably Mr. Pregi Padeachi, who is a close friend of ex-Deputy National Commissioner Vinesh Kumar Munu, who is currently alleged to be involved in illicit tobacco trade. And 5, he has no security clearance and would not get security clearance because of his covert criminal activities and questionable business activities. Now, these are allegations. They're not factually sound, but they're allegations. Now, when we got the allegations, we carry out some background checks, as I've mentioned. And in this case, what we did was we decided to have a look at General Khan. So attached to the email that we sent was the document, which is now pages 218, 219, 220, 221, 220, right up until, well, it's all these pages, right up until page 237. Because pages 218 to 224 is our research, it's the research we've done. But when the person gave me the tip-off, the person supplied me with the pages 225 to 237 as what that person considered to be substantiating the allegations. And it's not our position in life to make any findings about these sort of things. So when we get these type of allegations, what we do is we raise it. And the only place to raise such an important matter as this is with the National Commissioner. So we attach all these documents. As I've mentioned, Commissioners, pages 218 to 224 is our own research. And from our own research, we were able to see that at that moment in time, remember we're going back to 2021, General Khan was an active director of 10 companies. Now, when we look at some of those companies, which we obviously did some background checks on, we were able to establish that some of the companies were involved in the spare parts business of motor vehicles. And you can see a couple of them there. One is called Spares Oasis. We were able to trace the premises where spare parts for motor cars are being sold from. Another one is called Magic Motor Spares. So when you look at all this, and by the way, there's a PTY called Spares Oasis, and there's also a CC called Spares Oasis. So we take all this information, and then we look at the lifestyle of the individual concerned. And the lifestyle audit that we did gave the indication that this was not a person living on a Major General's salary. It was a lifestyle of a person in a much more affluent position. So all we did was simply supply the information and then say, there you are, that's it. We leave you to get on with it. And it's not our job then to go knocking on the door and saying, hey, what have you done about this? What have you done about that? Because our function is just to supply the information. And that's what we did. And that's made clear in my statement on page 11. And in my email, I think I've said, we find it should be impossible for a full-time Major General in the police to be moonlighting as a director of 10 businesses. And at least 2 of those businesses indicate a trade in spare car parts, an activity diametrically opposed to the work of crime intelligence, given the high levels of vehicle crime in Gauteng. So we're just making the point. That's it. And we left it at that.
Okay. You then, firstly, did you ever receive a response to your complaint?
No.
You deal with another annexure at paragraph 1.4.2.
Before you do that, Mr. O'Sullivan, I'm looking at your page 218 in that big bundle.
Page 218, yes.
Yes, you've got that list of properties there. I just want to understand, well, it starts at 218 and it goes to 219. So you've got a list of properties and then you've got dates. So if we start at 218, the first property has got a purchase date, right?
Yes.
And then you go to 219.
So what 218 shows 2 properties, and on 219, so when you're doing the search, if you click with your mouse where it says title deed number, it generates the pattern that you see.
The reported 219.
So it's giving you an explanation of where that property is and what the purchase price was and whether there's a bond and the transfer document number and so on. So that's the information that you would gain from that. And then,
Yes.
of course, you're able to get the address. And as you see, the one is based in Houghton Estate.
Yes.
And
Let me ask you my question. It's about the dates that I wanted to ask. What is the relationship between the dates in the first box with the heading properties and then the dates in the box with the heading addresses? There's a different...
Oh, yes.
You
So
see
what happens is every time any individual applies for credit or opens an account or anything of that nature where somebody does a credit check, when a person does a credit check on an individual, they list the data that that person supplies when he does a credit check. So you would quite often end up with a situation where here, for example, where it says addresses, that date would relate to when that person supplied that address to either a credit provider or an account provider.
Okay. Thank you.
Thank you, Commissioner Baloy. At paragraph 1.4.2, still at your page 11, you introduce an annexure N.
Yep.
Can you deal with the contents of your paragraph 1.4.2 and perhaps in so doing, place into context how you obtain that annexure N and under what circumstances?
Yes.
Yes,
Thank
please.
you, Commissioner. So when I was preparing my evidence for the Commission, during that process, I had to engage in, I suppose, a toing and froing process with Advocate Chaskelson, where I would be drafting certain things. And I said to him, oh, by the way, you know, this is what happened insofar as Major General Khan is concerned. And he said, did you ever see a letter from Ian Levitt, attorneys, complaining about you? And I said, no, I've never seen such a letter. He said, well, would you be interested to know there is such a letter? And Advocate Chaskelson forwarded this letter to me, and I was quite gobsmacked to see it. Because here I am making a complaint by way of a tip-off, and the information that we've supplied with that tip-off. And I supplied that complaint in, let me have a look at the date.
24th of May, 2021.
24th of May. So I supplied that tip-off on the 24th of May. And here we are 30 days later, or 31 days later, a month later, on the 24th of June, with this complaint coming through from Ian Levitt addressed to General Sitoli. And it's coincidental that my email is addressed to General Sitoli. Now, General Sitoli never came back to me about my complaint.
And your annexure N starts at 238. That is then the letter that you say was written, addressed to the National Commissioner
Yes.
by General Khan's attorneys.
Yes, and I've analysed this letter, and my problem with it, apart from complaining about me highlighting alleged unethical conduct on his part, the lawyer doesn't address any of the allegations whatsoever. No once does he say my client has done nothing wrong. The whole thing is about complaining about Paul O'Sullivan.
Yes. And at page 239, the same document overleaf, this letter advises the National Commissioner that a meeting subsequently took place between their client, I take it Mr. Khan, and yourself.
Yes.
Can you deal with the contents of that first paragraph?
Yes.
That suggests that a solution was reached.
So, thank you. Commissioners, you have to read paragraphs 4 and 5 together because they belong together.
Yes.
In paragraph 4, he makes the statement that he came to see me on the 15th of June, 2021. It could be correct. I can't remember because I can't remember back that far, but I do remember him coming to see me. And I was quite flabbergasted when he came to see me because when he sat in my boardroom, he said, "You've made a complaint against me." I said, "No, I haven't. I'm hardly going to admit that I've laid a complaint against him, because if I say to him, yes, I've made a complaint, here's a copy of it, I may be guilty of the offence of defeating the ends of justice." So I decided, no, I'm just going to deny it. And then he says in this paragraph that at this meeting, I offered to confirm under oath that I hadn't made a complaint against him. Well, I just want to place on record that I never made such an offer. However, if we go on to paragraph 5 of the same letter, the lawyer says, "Pursuant to the meeting, our client made further inquiries and reliably ascertained that Sullivan," they obviously mean O'Sullivan, "was not being truthful, and that in fact not only had Sullivan laid criminal charges with the DPCI, but that Sullivan had accessed our client's personal information in doing so, and in contravention of the Protection of Personal Information Act, POPI." And as I've pointed out earlier, we can access personal information, but not on an arbitrary basis. You can only do it if you're investigating a potential fraud, or for fraud prevention, or for corruption prevention, that sort of thing. So you don't just pick a person at random and say, "Oh, let's dig into this person." There has to be some probable cause, shall we say. So the tip-off was what made us do the look at this situation, and then we supplied the information. So quite clearly, since I'd sent that email to General Satoli with a copy to General Libia, I've not shared it with anybody else. So either somebody at their office or they themselves have shared that information with General Khan. So I've now got him coming to my office demanding to know why I've laid a complaint against him. So I've had to deal with that issue. But I just denied it. I said, "No, I didn't lay a complaint against you."
Did you ever pursue either General Libea or General Sitole regarding your complaint to establish what had become of it?
So as I mentioned earlier to the commissioners, if I had to pursue every single tip-off that comes through our office to the nth degree, in other words, to keep knocking on the door, well, we're eventually going to become a nuisance to somebody. We receive the information, we validate it, and we pass it on. We package it and we pass it on. That's all we do. It's not our job to investigate it. So we just look at it, pass it on, and then we believe it's up to the police. And in this case, it was up to either General Sitoli or General Libia to look into it. But as I've said in my statement, I didn't hear from them again. So I'm assuming they didn't look into it.
In your statement, page 12, paragraph 1.4.4, you then introduce Annexure P, which would be your correspondence with General Masemola of 31st July 2023.
Yes.
And I understand from that communication that you shared the same Annexure M that you had originally written to General Sitole.
Yes.
With General Masemola. You deal with those issues at your paragraph 1.4.4.
Yes. So what happened there, Commissioners, on the 30th of July, 2023, which is now 2 years after I've laid this formal complaint with General Sitole. By this stage, the Commissioner of Police is now General Masemola. So on the 30th of July, I look at News 24, and there's this scandalous article, which is attached as Annexure O.
That's at page 241.
241, where it refers to top cop attending EFF gala, a shameful, offensive slap in the face of South Africans. And it talks about General Khan, and it talks about the fact that his ticket for General Khan at this EFF gala dinner had been paid for by, shall we say, associates of General Khan, who were allegedly involved in the illicit tobacco trade. So I see this, and I think, wow, this is not good. It's 2 years since I've sent a formal complaint through to General Sitoli and General Libya. Now, I decide I'm not going to engage with General Libya again because I've already engaged with him and he's done nothing. So I write to the new, or then relatively new, Commissioner of Police, which is General Masemola.
Yes.
On the 31st of July, which is the day after I've read this article. And I say, dear General Masemola, it's most disheartening to read in the media about how rotten crime intelligence is. Police management know about this man Feroz Khan, but what is going to be done about it? And by the way, when I send this email, I attach to it, so I'm forwarding the original email that I've sent 2 years earlier. And I said it will take someone explaining to understand how this man can jet around the country in a jet owned by a tobacco smuggling kingpin, Syed. Of course, I could have used the word alleged, but I didn't. And also drive around in Lamborghinis. I said, does it need for him to be caught with a smoking gun for the management to get rid of him? And when I talk about management commissioners, I'm talking about management of the police. And then I say, I'm copying the editor of News 24, as I believe the people of South Africa have a right to know what's been going on. And then I say, I finish the email up with, although General Sitoli did not bother to respond to my mail in May 2021, perhaps you will be able to do so.
Did you receive a response to this communication? And if so, what was, in summary, the response?
No, Commissioners, no response whatsoever. And by that stage, I think it became the order of the day. So that didn't stop me from making the communications, because later on, when we have a commission of inquiry like this, I can show, but hang on a minute, this is not the first time these things have copped out of the woodwork. Here we've got the evidence that I've been continually supplying information and evidence, and nothing has been done about it. And that's why you're going to find later in my affidavit, I make it clear that actually police management does not take action against senior police officials unless they have an agenda or motive for doing so. And that is part of the problem that we have with the police service today.
You don't say in your statement, but besides the newspaper articles and the reports you filed following whatever investigations you did around General Khan's companies, was there any evidence that you provided to either General Masemola, General Libya, or General Sitole that constitutes evidence to support the allegations you make in your previous communication to them of May 2021? Or is it what you have shared with the Commission now that you made available to these generals?
I was not able to supply any prima facie evidence. If I had prima facie evidence, Commissioners, apart from notifying the management of the police, I would have opened a criminal docket. But you cannot open a criminal docket based on a hypothesis. So what we would have expected to do as Forensics for Justice, we expected the management of the police to take this and look at it.
Yes.
But unfortunately, nothing was done.
Noted. Is there anything else on that subtopic you would like to highlight? Because you start a new one at your page 13.
No, I think we've covered that in sufficient detail.
Okay. Then if we turn to page 13 at paragraph 1.5, You now introduce a different topic. You headed the erstwhile Acting Commissioner, Lieutenant General Pahlane. You deal quite extensively with this matter. If you could briefly then address yourself to it.
Yes.
And as you do so, because at your paragraph 1.5.3, you introduce the DPCI judge report, which is your annexure Q. If you could just highlight the relevance of those findings in that
Yes.
report
Yes.
to the terms of reference of the commission. Thank you.
So, what I'm trying to get across here, commissioners, is that if you have an entity such as Forensics for Justice, which at the end of the day, it's a not-for-profit organization or charity, whatever you want to call it, the reality is that we are not out there to conduct ourselves in a malicious manner. We're out there to help bring accountability specifically in the criminal justice system. So the purpose of this section of my evidence is to show that if you step out and expose corruption within the criminal justice system, you actually become a target yourself. And that's exactly what happened here. And if I can place on record that in respect of General Pahlane, that between 2015 and 2017, I carried out extensive investigations and lodged various criminal complaints against General Pahlane with IPID. I supplied copies of my criminal complaint to then Deputy President of South Africa, now President Cyril Ramaphosa. As a result of the complaints I made against General Pahlane, I was singled out for unlawful action by corrupt police officials at the instance of both General Pahlane and other senior officers. The crimes against me included multiple arrests, multiple raids on my home and offices, kidnapping, torture, unlawful imprisonment, and multiple attempts at murder by proxy. And I can go into a lot of detail on that, but to save time, I'm not going to. But we had a situation where the attempts to murder me were being instigated by senior police officials. I was unlawfully arrested and detained over 2 years later for using my Irish passport. The reason I used my Irish passport was because at the time Radovan Krejcir wasn't in jail, but he had cops on his payroll and they were waiting for me to come back into South Africa so they could arrange for me to be murdered. So what I did was I slipped in on my Irish passport instead of my South African passport. And 2 years later, I get arrested for that because that's all they could find to arrest me on. And they detained me for 4 days. We talk about General Pahlane. The evidence will show that he's currently on trial, on various trials, and the sum total of the corrupt contracts exceeds 500 million rand. Now, those trials are ongoing. So, in 2016, as a result of all this unlawful conduct against myself, which was coming from DPCI, and by that stage, I'm saying DPCI was captured and the National Prosecuting Authority was captured. As a result of this unlawful conduct, I laid a formal complaint with the judge for they call him the DPCI judge. It was a retired judge. And I laid a formal complaint comprising 3 lever arch files. And that complaint was laid in 2016, towards the end of 2016. On the 6th of October 2022, the judge released this...
Sorry. I think paragraph 1.5.3, the last line, an amendment should be made there. It says you laid your complaint in July 2026.
Thank you. It should be 2016.
Thank you.
That's a typo for which I apologize. So, in fact, I laid the complaint in July 2016, and it comprised of 3 lever arch files with all the evidence. And then I left the DPCI judge to get on with it. And the DPCI judge issued a report, which is contained as Annexure Q at 246. Now, that's a very lengthy report, Commissioners. So what I've done, on page 14, I've extracted the relevant sections of the report, and I'd like to read it into the record halfway down page 14, and it continues on page 15, and it finishes at the top of page 16, so it's only about 2 or 3 minutes of reading. And the DPCI judge made the following findings against Major General Mokateri. In respect of Mr. O'Sullivan's arrest and the manner in which it was carried out at OR Tambo International Airport on 01 April 2016 in the presence of his children, needlessly detained for several days for what is a minor infraction of having allegedly contravened Section 26B of the South African Citizens Act, and his dubious prosecution in State versus O'Sullivan, case number B803/2016 Kempton Park, for which he was acquitted in terms of Section 174 of the Criminal Procedures Act. Major General Mokateri is found guilty of having seriously and unlawfully infringed the rights of Mr. O'Sullivan as contemplated in Section 17L of the SAPS Act. As far as the cold cases against
Mr. O'Sullivan, here? Yes. Why Mr. General Mokateri? Is it because he's the one that effected the arrest?
So,
was he the complaint? What happened?
No, Commissioner. General Mokateri had been, and I'll be able to prove this, it's not just an allegation, General Mokateri had been unlawfully appointed as the head of DPCI in Gauteng during the state capture process. So you had General Ntlemeza. I'd opened a case against General Ntlemeza before this, by the way. I'd opened a case against General Ntlemeza. I'd opened a case against Lieutenant General Pashlani, who was the acting Commissioner of Police, and I'd opened a case against General Mokateri. So Mokateri was the senior person who led the group of about 30 police officials who targeted me and Forensics for Justice and the staff that worked for me. So there was, as you will see, there was a campaign over several years against us.
Thank you.
Shall I carry on? As far as the cold cases against Mr. O'Sullivan that Major General Mokateri unearthed and reinvestigated are concerned, it's certainly permissible for Major General to have done so. What he has made himself guilty of is falsely claim under oath, as the DPCI judge observes in para 26 above this report, paragraph 61, one has to be extremely gullible to accord any credence to Mokateri's averment that pursuant to O'Sullivan's arrest on 01 April 2016 at OR Tambo International Airport, all the complainants in the cold cases magically came out of the woodwork and urged that charges they laid against O'Sullivan years before be resuscitated or reopened. Such coincidence defies credulity, and I reject this explanation as a figment of his fertile imagination. A conspectus of the facts, circumstances strongly mitigate against it. All 9 reinvestigated cases proved to have been moribund, and none of them survived as far as could be determined. Now, Commissioners, if I can just stop there and explain to you what those cases related to, those 9 moribund cases. Apart from running Forensics for Justice, I have other business activities. I run a property company and I run a forensic practice. And the forensic practice, we carry out forensic investigations for corporations. So if fraud has been committed or corruption has been committed within a corporation, they'll engage our services to carry out an investigation. And quite often it would entail us then assisting that client to open a criminal docket for fraud or theft or corruption or whatever the case may be. And in the criminal justice system today, we have a situation where quite often, to distract attention away from their own criminal activity, you get the suspects in these cases opening cases against the people who are investigating them. It goes on all the time. And I would say probably over 200-300 investigations that we've carried out, there's probably been 10 or 12 where the suspects have opened cases against us. And those cases have got no legs at all. It's just a distraction. So I just wanted to explain that. Then the DPCI judge goes on to say, it is common cause that the relationship between O'Sullivan and Mokateri was and remains strained, if not acrimonious. I am acutely alive to the fact that Mokateri may have harboured an ulterior motive for reopening the aforesaid cold cases. Then he goes on a bit further. However, I'm satisfied that the reinvestigation of the cases was meant to and did harass O'Sullivan. It was designed to have a chilling effect on his forensic investigations and to fight corruption. Sometimes it appears he acted unconventionally. That's me they're talking about. But so far as the DPCI judge could discern, not unlawfully. Well, of course we act unconventionally. And that's why we have the success ratio that we have, because we step above and beyond what normal people would do. Then he goes on to say, at paragraph 63, which is on page 15, to put Mr. O'Sullivan to such unwarranted great expense to defend the unmeritorial cases was prejudicial to him and seriously and wrongfully infringed his constitutional rights as contemplated in section 17L of the SAPS Act. Then he says at 64, the failure by Mokateri to obtain a security clearance. Now this is the crux of the issue, Commissioners. This is the most important part of this whole story. The failure by Mokateri to obtain a security clearance for almost 3 years is unlawful and a transgression of section 17E of the South African Police Service Act and section 2A of the National Strategic Intelligence Act. Mokateri disgracefully tried to shield behind his employer. However, he had a concomitant duty and responsibility to obtain the clearance. In addition, his appointment set out in paragraph 44(2) above was subject to a security clearance of top secret. And I need to pause there to mention, Commissioners, the law is crystal clear. You cannot be appointed as a provincial commissioner of DPCI if you don't have top secret security clearance. He never had it. And then he says, nevertheless, no direct connection can be made or line drawn between the Mokateri's spurious appointment as provincial head of the Hawks and the woeful treatment meted out to O'Sullivan. Be that as it may, he should never have been appointed to such a lofty position. Least of all, he should not have been given a permanent contract of appointment under the sketched prevailing circumstances. Now, Commissioners, at the end of the report, he makes a conclusion and he recommends to the Commissioner of Police, General Masemola, that Major General Mokateri should be dealt with. And what's interesting here, Commissioners, is that Major General Mokateri was the provincial head of DPCI. Now, DPCI, in terms of the Glenister judgment, is handled in terms of Section 17 of the Police Service Act. So it's a separate section of the police service. It's supposed to be separate. And if you're appointed as provincial head of DPCI, and then you're found wanting and you don't have security clearance, what happened in this case? Instead of him being dismissed, he was just moved sideways into the police service from DPCI. And I wasn't happy about that. In fact, I was quite livid. And I continuously wrote to General Masemola and I requested him, why hasn't this person been dismissed? To cut a long story short, he was eventually dismissed, but not to do with the DPCI judge's report, to do with another matter completely. So I just wanted to record those facts that General Masemola did not lift a finger to deal with the DPCI judge report, which report was issued in 2022. And General Mokoteri only finally left the service towards the end of 2024, which means he sat on the payroll, the taxpayers' payroll, for a further 2 years, twiddling his thumbs. He wasn't working.
Mr. Sullivan, just a small issue. Your paragraph numbers where you quote the DPCI judge's report.
64, did you say?
Yes, they are incorrect. Sorry, on page 15 of your statement, at least in two respects, you seem to have quoted the unnumbered quotations, but you've given them paragraph numbers. So your paragraph 61 on page 15 in the judge's report is just an unnumbered quotation.
Let me just have a look, sorry.
If you go to page 319 of the annexures, it's just two paragraphs that we need to correct.
I'm just going to have a quick look here. 64, yeah. So it would appear to me, if I can beg for your forgiveness, so what's happened is I've created this on Word,
Yes.
and I've typed it in, and sometimes Word changes the paragraph numbers without your permission. And I think that's what's happened here.
Yes.
So for the purpose of correctness, we probably need to say,
So this is what we will do. Let me assist you. What you have numbered paragraph 61 on page 15 is an unnumbered paragraph in the judge's report. It's just a quotation of the earlier evidence on paragraph 26.
Yep.
So that 61 must go out.
Yep.
Which means what you have as 62
Becomes
will
61.
then be 61.
yep,
And
63
then
becomes 62.
What you have as 63, that's
Yep.
another
Yep,
quotation, so we will have to correct that. And then what you have as 64, which says the failure, will be 63 according to the report you see on page 320.
yep.
Yes, and then what you have as 65 will then be 64, the paragraph that starts with nevertheless.
I have it.
Yes,
Thank you.
thank you.
Thank you, Commissioner Khumalo. My sense is that you have covered everything you have set out in your statement regarding General Patlane, your complaint regarding General Patlane and the DPCI judge report. Is there anything else that you conclude by saying, notwithstanding the referral of that report to General Masemola, General Masemola failed to take action?
Yep.
If I understood the report correctly, the action General Masemola was invited to take was against Major General Prince Mukotedi and not against General Patlane, was it? If you look at your summary at page 16.
Your page number, sorry?
Your summary at page 16, paragraph 1.5.6, you quote the conclusion reached by the judge.
Fanny Masemola.
You say this, and it quotes under capital A in parentheses, this is an appropriate DPCI judge's report deserving attention of the National Commission of
Correct.
Police.
This is the conclusion of the DPCI judge's report.
Yes.
If you look towards the end, I should give you the page number there.
We'll locate quickly the page number for you. The point I'm making is that was a conclusion for the purposes of taking action against Major General Mukotedi and not General Patlane. Am I reading it correct?
I don't mention General Patlane.
Yes, I'm saying the topic deals with General Patlane. The DPCI judge's report makes findings, is in large part concerning the conduct of Major General Mukotedi and makes findings as you have tabulated them at page 14.
That's to be seen on page 326
Yes.
of the evidence. It refers to deserving the attention of National Commissioner General Masemola.
Yes. And I'm saying what deserves General Masemola's attention is what you have set out at page 14
Yep.
in the boxes. The following findings against Major General Mukotedi are made. It's
Correct.
those findings that are brought to the attention of General Masemola,
Correct.
and General Masemola is called upon to take appropriate steps.
Which is what should have happened.
Yeah, and the only point I sought to make was that this is not about General Patlani.
No, it's nothing to do with General Pashlani.
I fully, that clarity.
The only thing it's to do about General Pashlani is that all of this conduct happened against me
Yes,
because I opened a criminal complaint against General Pashlani. So everything that's listed here happened against me and others that were connected to me. But the driving force, according to the DPCI judge report, was General Mokotedi, who was acting on the instructions of both General Mkwanazi. It doesn't say that in the report, but we know it for a fact. General Mkwanazi and General Pashlani.
okay, understood. Yeah, I just wanted to make that clarity.
Yeah.
And do you know, are you aware of any steps then that General Masemola took against General Mukotedi?
None at all.
And at your paragraph 1.5.8, you confirm that General Masemola, as you say, quote unquote, did not lift a finger to implement the recommendations of the DPCI judge.
So, sorry, I didn't hear it. 1.5.7, I've said, the relevance of the conclusion in the DPCI judge's report mentioned above is not lost on me and should not be lost on the Commission. General Mokotedi was never, from the date of his unlawful appointment, lawfully in his post, because he never had top secret clearance or secret clearance. Instead of dismissing him, General Abaya unlawfully agreed with General Masemola that it could simply be moved from DPCI to SAPS. So that's moving the problem instead of removing the problem. He was moved to the division known as Inspectorate, which functions or is supposed to function as the internal standards monitoring the police. It can be likened to hiring mice to guard the cheese, because here you have a situation where General Mokotedi has now been moved out of DPCI, where he can't be because he doesn't have top secret clearance, plus the DPCI judge has said he must be dealt with, and he's moved into the police. They have nowhere else to put him, so they've put him in the Inspectorate. Now, the Inspectorate is quite commonly known as the departure lounge in the police. If they haven't got work for a senior person, they stick them in the Inspectorate, and that's often where these generals end up before they find another job somewhere. So that's why it's colloquially referred to as the departure lounge.
Thank you. That would then lead us to your paragraph 1.5.9 at page 17, but you introduced a new topic there.
Yes.
And you heard that General Mkwanazi's unlawful assistance to General Patlani.
Yes.
Before you deal with the contents of that paragraph, you reference an affidavit by a Mr. Humbulani Kuba, which you invite to be tested. Presumably, the invitation is extended to the Commission.
Yes.
Commissioners, that affidavit is not part of your bundle. Mr. O'Sullivan has made a copy available, and we've got copies for you. Because of where it is referred to, we have an extra Q, which is the DPCI judge report. We propose this be the next document based on the structure of his statement, and we propose that it be marked Q1, so that at least we can associate it with paragraph 1.5.9 easily. Now, Mr. O'Sullivan will talk to this affidavit, but the commissioners will notice that the first document is a 2-page affidavit dated the 16th of January 2026, and that affidavit seeks to introduce an earlier affidavit dated October 2020, according to the narrative, but the copies you have are undated. And it is stated that this particular October 2020 affidavit was prepared for the purposes of the Zondo Commission, but it would appear to have not been either finalized and filed, or the challenges that Mr. O'Sullivan has had is to locate a signed and filed copy of the annexure to this affidavit. So that's the context of these documents. Technically, there are 2 affidavits, the latest one now of 2026, and the 2 that are attached. The difference between the 2, as I understand it, is that the one has got track changes, the second doesn't. It's a clean copy, but it's one and the same document. I hope that will assist in navigating this new annexure.
Yes.
Then, Mr. O'Sullivan, you start at, you may deal with your 1.5.9. You state that you are informed, I don't know by who, that you do not need to go into the details of the unlawful prosecutable conduct of General Mkwanazi pertaining to General Pashani, relating to the offenses I believe were committed in 2017 and 2018. It is in our engagement regarding the allegations you make there that you introduce Mr. Kumba's affidavit, which we now have marked Q1.
Yes.
So you may deal with the issues that you highlight there.
Thank you. So, Commissioners, to get the drift on this, to get an understanding of what took place here, we have to remember that I opened the case against General Pashlani, a criminal complaint. I opened that complaint in February 2016. And in that complaint, I alleged very serious corruption on the part of General Pashlani. And my docket set out chapter and verse. Remember what I said earlier, if I get a tip-off and there's no evidence, we just supply the information. In this case, it was more than a tip-off. I had evidence. And I took all that evidence and I packaged it and I opened a formal docket with IPED. But unfortunately, by that stage, IPED was captured. It was during that state capture period. And IPED was captured by virtue of the fact that 2 crime intelligence officials have been appointed to work in IPED, and they were allegedly controlling all of the investigations that IPED did. And then you had a situation where I opened my case with IPED in February 2016, and the complaint I laid was, a copy of it was supplied to General Pashlani instead of the matter being investigated. And that led to the attacks against myself and my staff. So, but what happened while all that was going on was there was a matter in the Supreme Court of Appeal, in fact, no, sorry, it was the Constitutional Court. And that was the matter of Robert McBride versus the Minister of Police. And the Constitutional Court ruled that the suspension of Robert McBride was unlawful, and it was an overreaching by the Minister of Police. And Robert McBride was given his job back, which meant that in November 2016, 10 months after I've opened this case against General Pashlani, the case suddenly came alive again. So I sat down with the people from IPED and I explained to them exactly what had gone on and the fact that for 10 months there'd been no investigation whatsoever other than supplying General Pashlani with a copy of the docket. So then what happened was IPED formed a small task team. And my understanding is that the task team was headed up by this gentleman, Hambulani Innocent Kuba. And he is currently the Limpopo director of IPID. At the time, I believe he was also the Limpopo director of IPID, but he was brought to Pretoria because they wanted somebody from outside the province to case manage my complaint against General Pashlani. And that's what Hambulani Kuba did. And he reported directly to Matthew Sissoko, who was the head of investigations at IPID. So what happened was, there were a number of legs where General Pashlani attempted to derail the investigations into him. And those legs took various forms. One of the forms, and I'll say it briefly, was the appointment of the so-called Northwest team, which was General Mabula and a whole lot of brigadiers and colonels. And their job was to try and find dirt on the IPID investigators and myself. And they were quite busy with that. In fact, I was unlawfully arrested and charged, which is part of those other cases that eventually blew away. But what happened as well during that period was we had, according to Hambulani Kuba, we had the unlawful conduct of General Mkwanazi. And I would like to just explain these pages that have been given to you now. I've got page numbers 333.1, 333.2, and so on. Now, 333.1 and 333.2 is a sworn affidavit saying that, look here, I can't find the original affidavit that I submitted in 2020 to the Zondo Commission. However, what I have been able to locate are the emails from the Zondo Commission giving me my draft affidavit. And I want to say that when I attach this affidavit, everything in there is true. And therefore, as you would know, making affidavits for a commission, it's an iterative process. It's not something that you just do and you're finished. You draft and then you add a bit and then you know, it's an iterative process. And this is the evidence. If you look at page 333.8, it's an email from Garth Holly, who was one of the evidence leaders at the State Capture Commission. And he's saying, "Hi, Innocent, please consider the attached statement that I drafted based on our consultation. We need to get as much corroboration as possible. I've raised a few issues on the papers. Please get back to me." This is what Mr. Kuba has been able to find. We've been in touch with Garth Holly, and unfortunately, the State Capture Commission, as you know, is wound down, and it's not possible to find the original statement that Hambulani Kuba made. And that's why I've suggested that I believe this person could be and possibly should be, briefly, because it's not a long story he has here, it's a very short story. And if you capture his story quickly, it's basically saying that in February 2018, he got a phone call from Major General Nemathensela of Crime Intelligence. By the way, when you see all these issues, I just want to reiterate, most of these issues emanate from crime intelligence. It's always, 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 there's something to do with crime intelligence. He stated that he blah, 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 he wanted to meet with me. He provided me, on page 333.4, if we look at paragraph 10, I remained in the lobby, so he's now at a hotel somewhere in Pretoria. I remained in the lobby while we waited for the anonymous witness. So Mr. Kuba thought he was going to be meeting a witness. He was in telephonic discussion with the witness. In one of his discussions with this person, I recall him explaining that we are already seated here waiting for you. Nemathensela and I had drinks, juice. while we waited for the anonymous witness. After one of his calls, this is now paragraph 11 on page 333.5, after one of his calls, Mkwanazi said to me that we could go now. We took the lift and went up to one of the floors. I do not recall which floor it was. When we got out of the lift, I saw Lieutenant General Mkwanazi. I immediately recognized him. I had interviewed him in the rendition matter. Mkwanazi asked us to switch off our cell phones and hand them to him. He took the phones and placed them in an adjacent room. Present in the meeting was General Mkwanazi, Mkwanazi, and me, so there's 3 of them in the room. I do not recall precisely how long the meeting lasted. I imagine that it took approximately 1 to 1.5 hours. I was present in the meeting with Mkwanazi and Mkwanazi. Mkwanazi started the meeting by talking about politics. He later explained that there were 2 IPID officials who had given Section 204 statements, Nkabindi and Mshlangu. Now, we all know who Nkabindi is. It's the same Cedric Nkabindi, who was subsequently dismissed or resigned from IPID and subsequently surfaced as the Chief of Staff for the Minister of Police. And he talks about Mashlangu. Mashlangu was one of the IPID investigators. His name was Mandla Mashlangu. It doesn't say that here, but I know who it is because I knew the person. He was approached also to give a witness statement. Unfortunately, he can't testify today because after he refused to sign the witness statement, he was subsequently murdered. And then it goes on at paragraph 15. Mkwanazi asked me for information that could implicate McBride in criminal wrongdoing involving Mr. Paul O'Sullivan. So the narrative, I should mention at this stage, that was being driven by General Pashlani was that I had captured IPID, that I had taken over IPID. And General Pashlani would even go on TV and refer to it as OPID. He went into Parliament on the 17th of May in 2017 and referred to IPID as being OPID. Very sarcastic. He wanted to know what they were involved in and how they were involved. He's talking about General Mkwanazi asking him about myself and McBride. I explained to him that I did not spend time with McBride socially and was accordingly not in a position to provide him with details of McBride's relationships with O'Sullivan. I should emphasize that at that point, at no point did he suggest that I should lie. I pause at this stage, Commissioners, to mention the only relationship I ever had with Robert McBride was the fact that he was the head of IPID. And after he was reinstated by the Constitutional Court, I went and met with him and told him about this case against Pashlani that was gathering dust for the previous 10 months. And that's as far as it went. He goes on at paragraph 16. Mkwanazi said that I would be taken care of, that I, who held the post of Chief Director, which would be at the rank of Major General in the SAPS, would be promoted to rank of Lieutenant General, which was on the same rank as him. Mkwanazi indicated that both Nkabindi and Mashlangu would also be promoted into higher ranks within the SAPS because of their cooperation. He explained that one of them had not yet signed. That was, I can tell you, was Mashlangu, because we know Nkabindi had signed. When I was leaving, he said that I should think about it. He said that he was meeting with Nkabindi and Mashlangu that evening. And then he talks about going back to the office and explaining all this to Matthew Sissoko, who was his direct boss, who was waiting for me. We discussed a lot about whether it was true that these 2 IPID officials had turned Section 204. We got the sense that Mkwanazi was trying to fish to get me to tell him what I knew. My sense was that he wanted to give me the impression that he already knew and that I should tell him since the information would already be shared by my officials. I returned to my hotel at approximately 21:30. I went to check at the hotel room of Nkabindi. They were in the same hotel. I knocked on his door and he did not answer. I phoned Sissoko and said this might be true because Nkabindi was not there. We were staying in the same hotel called Absolute Farringdon in Hatfield. At about 2400 or 0100, I heard Nkabindi returning to his room. I told myself I was not going to sleep until he returned. We had adjacent rooms. I sent Sissoko a message via WhatsApp saying he'd just come back. Mashlangu later told Sissoko that he had been approached. I think Sissoko told McBride, who called a meeting to find out if anyone was approached. Mashlangu confirmed that he had been approached. He said that he'd been approached by Como. Now, Como was the crime intelligence official working in ARPID. And the two crime intelligence officials been placed by the Minister of Police into ARPID to manage investigations. In fact, how can you have crime intelligence officials working for a so-called independent body like ARPID? But what in fact happened, and I can just mention this on the record, that when Mr. McBride was reinstated to his position by the Constitutional Court, these two officials absconded from ARPID and never came back. They went back to crime intelligence. And then he says, I was expecting him to include Mkwanazi, but he did not mention Mkwanazi. On the one occasion, he got angry with me for mentioning Mkwanazi because he made it clear that he was a family friend. He did not want me to mention the name of Mkwanazi. So the point I'm making, Commissioners, is that some sort of credence has to be given to this. Because here you have a situation where on the 6th of July last year, General Mkwanazi calls a media briefing, a very dramatic, fantastic media briefing, where he talks about interference in investigations. In fact, according to this statement, that's exactly what he was doing in the Pashlani investigation. He was interfering with ARPID and trying to get ARPID members to leave ARPID and give them some dirt on Robert McBride and allegedly against me as well.
Mr. O'Sullivan, where do we see in this affidavit that the overture or the approach by General Mkwanazi related to the Pahlane case? Where do we see that in this affidavit?
So you cannot see that in that statement. You would have to be involved on the ground at the time, as I was, to know what was going on. And all of this was going on at the same time as the Pashlani investigation. And in my opinion, my humble opinion, the only way you're going to get to the bottom of this is either to get a detailed sworn statement from Mr. Kuba or get him to come and testify. I cannot believe it can take long for him to cover these aspects.
It may be so. It may be so that it won't take long, but I'm noting, for example, that Mr. Kuba did this two-page affidavit, the first 2 pages.
Yep.
On the 16th of January 2026, the commission was sitting. I don't know for what purpose he prepared this
My
affidavit.
understanding, Commissioner, is that it was for the ad hoc committee of Parliament.
Yes. The point I'm making is that as recent as January 2026, where he prepares an affidavit, he doesn't say anything about General Mkwanazi approaching him to interfere as a measure to interfere in the Pahlane investigation. In fact, at paragraph 18, he says, our sense was that he was trying to fish to get me to tell him what I knew. He doesn't say about what, but he has opportunity in January to say more on these earlier affidavits, and in particular, that he felt, even if it's just I felt, he was speaking to me, or he wanted me to interfere, or he was interfering in the Pahlane investigation. He doesn't say that. So my question really is, if we rely on these 2 affidavits, well, including the recent one, so all 3, 2 drafts, and this latest affidavit, there isn't anything in it that speaks to the very specific topic you're speaking to, which you say this is evidence of interference.
So,
And unless I misunderstand your evidence, I thought what you're saying is this is evidence of interference.
these documents themselves would not amount to evidence on their own of the interference. They would have to be read together with the High Court cases that took place at the time, where IPID launched urgent application to stop police interference in their investigation into Pashlani. And they were successful in that they got an order that the police must not do a counter-investigation. Now, I was on the ground at this moment in time, so I knew what was going on. So I knew that this related to Mandla Mashtangu, by the way, Cedric and Kabindi. If you look at this, Commissioner, you will see that he does mention that Mkwanazi was fishing to see what he could find out about Robert McBride and Paul O'Sullivan. And my only involvement with Robert McBride at that moment in time was the Pashlani investigation. I had no other involvement. That was it, short and sweet. So it's hard to draw that conclusion, I agree with you, but I do believe it's warranted, if possible, to either get the gentleman in or have one of the investigators take a more detailed sworn statement from him.
Isn't the problem with that proposal that let me start. I can understand when you say you were on the ground, and because you were on the ground, you are able to draw connections between this approach to IPID and what you knew was happening on the ground, including that the General Patlane matter was taking life. So I can see, I'm prepared to accommodate that in your connection of the dots. That's the picture it creates. The difficulty, at least for me, is we have a statement here where we have that unsigned affidavit where Mr. Kuba makes no reference to the Patlane matter. And that is compounded by that as recently as January 2026.
Yep.
He gets to prepare another affidavit that attaches the unsigned one, and he doesn't speak to...
No, exactly.
He doesn't make that allegation.
No, I fully agree with you. If I was involved in the preparation of this statement in January 2026, I would have crossed the T's and dotted the I's and made it crystal clear what it was involved in.
Yes.
We know for a fact that Cedric and Kabindi left IPID, tried to join the police as a brigadier, and I wrote to General Sitoli at the time, and I said I would bring a court application if he's appointed in the police. So we know that was the status with Cedric and Kabindi. At the end of the day, this is crying out for further, shall we say, investigation. I understand that on its own, it's not a smoking gun, but I do believe there is a smoking gun to be had here.
Thank you.
Thank you, Commissioner. I have a similar question. Looking at the same affidavit, starting from paragraph 10, what you've basically read into the record.
So what page are we on?
I'm in Annex Q1, Kuba's affidavit that we have just tendered. I'm at page 333.4. And I say it's only at paragraph 10 that Mr. Kuba deals with the engagement with General Mkwanazi and following.
Yeah.
Now, my reading of that is that what Mr. Mkwanazi wanted is what's reflected in paragraph 15. Mkwanazi asked me for information that could implicate McBride in criminal wrongdoing involving Mr. Paul O'Sullivan. And if I read the document correctly, that's what seems to be the gist of the engagement between
Correct.
the two. Now, if we look at your statement at page 17, at paragraph 1.5.9, You speak of unlawful prosecutable conduct of General Mkwanazi pertaining to General Patlani relating to offenses, I believe, were committed in 2017 and 2018, when General Mkwanazi was involved in unlawful attempts to prevent investigations and prosecution of General Patlani. And then you quote this affidavit. Similarly, this affidavit doesn't help us understand the unlawful prosecutable conduct you reference, unless you suggest that General Mkwanazi inquiring from Mr. Kuba whether he has information that could implicate McBride in criminal wrongdoing involving Mr. Paul O'Sullivan is the unlawful prosecutable conduct. Is that?
No, so that's why I've suggested, Commissioner, in my paragraph 1.5.9,
Yes.
I said I will not therefore canvass the matter. Safe to say that I feel very strongly that the evidence of Mr. Humbulani Kuba in this regard should be tested. In other words, it needs to be tested, because that's the only way you're really going to get to the bottom of the matter. I know what it is, but my knowledge is not evidence. It's just what I know. And I accept that it's not evidence.
I understand what you say. So you are inviting the commission to test and to the extent necessary, perhaps engage with Mr. Kuba so that we can determine the unlawful prosecutable conduct of General Mkwanazi and his involvement in unlawful attempts to prevent investigations and prosecution of General Patlani.
That's correct.
Okay, I fully understand. That then brings us to the end of that particular subtopic. And if we could then go to paragraph 1.6 at page 17.
Sorry, you have said you know this or you know about this, but your knowledge all on its own or by itself will not assist. What exactly do you mean when you say you know?
Because, Commissioner, at the time, way back then, when all this was going on, the multiple attempts at trying to derail the investigation by IPID against Patlani was going into the public domain and making these comments that Paul O'Sullivan was taking over IPID, which of course were false comments, absolutely false. Now you have this situation going on, and you have this parallel conduct in relation to Cedric and Kabindi. Let's just park Cedric and Kabindi to one side, because at the time this took place, Cedric and Kabindi, he went across to the other side. He left IPID and he went into the Patlani camp, and he was recruited into the Patlani camp by General Mkwanazi. And he provided a sworn statement in a High Court case where General Patlani launched an application to try and have the charges against him thrown out of court. And he failed. The court ruled against him. Now, that was Cedric and Kabindi that was making that sworn statement for General Patlani. But he didn't say, by the way, I was recruited by General Mkwanazi. But if you read this, Humbulani Kuba says that General Mkwanazi tells him, listen, we've already got Cedric and Kabindi on board, and we've already got Mandla Mashlangu on board, but he said one of them hasn't signed. Well, at the time, we found out that it was Mandla Mashlangu who hadn't signed, and he refused to sign. Unfortunately, he was murdered because of it.
Do you have any idea, Mr. O'Sullivan, for what purpose this statement was made for the ad hoc committee? the short affidavit to which are attached the draft statements?
Yes, Commissioner, because I obtained this affidavit from Robert McBride. Because when this ad hoc committee was going on, you had certain parties going to the ad hoc committee and, for want of a better expression, blowing smoke up their backsides with all these false claims. And you had this situation where they called as witnesses people like Robert McBride, and they tried to impugn his character. And they did the same to me. They tried to impugn my character. But unbeknown to me, and I only found out afterwards, Robert McBride obtained this statement and tried to persuade the ad hoc committee to call Mr. Kuba as a witness, but they didn't. So that's my understanding as to how the statement was obtained.
Also, it was filed with the ad hoc committee at the instance of Mr. McBride.
That's my understanding.
Okay. Okay. But was the context there to say that General Mkwanazi had allegedly committed unlawful prosecutable conduct? Was that the purpose for filing this statement, or was the purpose something else? Do you know?
My understanding, Commissioner, is that the ad hoc committee didn't obtain the statement. My understanding is that Robert McBride obtained the statement, and that when he obtained it, with all due respect, he didn't spend long enough cobbling it together. It could have contained a lot more detail. And this was a quick rush job that was done before his appearance at the ad hoc committee. If I was involved in doing it, it would have contained all the relevant data, but I wasn't involved, and I only found out about it later.
But what I'm saying is, I did not suggest that it was filed at the instance of the ad hoc committee, no. I'm saying, was it filed for the purpose of showing that General Mkwanazi was allegedly guilty of unlawful prosecutable conduct?
That is correct.
Even if it was at the instance of Mr. McBride. Was that the purpose?
My understanding, Commissioner, and I don't have the minutes of when Mr. McBride testified at the ad hoc commission, but his actual words were, "This is evidence of unlawful prosecutable conduct on the part of General Mkwanazi." And perhaps one of the researchers can find the PMG minutes of the meeting where he states that, because that in fact is what he stated. And when I heard it I didn't listen to him giving his evidence. I heard it later and somebody pointed it out to me, and I said, "Can I get a copy of that statement?" And that's what I got. That's what I said.
And would this have been prosecutable conduct relating to General Pahlane or yes?
That's what Robert McBride insinuated.
Wanted to, okay. All right, which I think, or rather in respect of which the statement does not seem to assist. No. And that's the point Commissioner Baloyi already took you through.
I agree with the Commissioner.
Yes, okay, all right. Yeah. Thank you.
Thank you, Chair. As I indicated, Mr. O'Sullivan, we're now at your page 17, and we start with the next subtopic, 1.6, General Mkwanazi, Mr. Kistia, and the Louis Vuitton bags. You reference in this part of your statement Annexure R, which is to be found at page 334. That is the article. That is the newspaper article.
Uh-huh.
And just to confirm on this topic, this is all you rely on, this is all the evidence you have about these supposed gifts by Mr. Kistia.
Yes. So
then if you may just quickly deal with...
I'm mindful of the time we're spending, so I'll try and be as prompt as I can.
Yes.
And succinct as I can. I had knowledge of these allegations from whenever it was, 2022. And I didn't do anything about it because it's just a media article. But what happened was, after the July 2025 media conference of General Mkwanazi, I started putting bits and pieces together. And one of the things I did was I instructed my attorneys in November 2026 to issue a subpoena to IDAC. And I've evidenced the subpoena as S1 and S2. S1 being the subpoena and S2 being the reply from IDAC. But the important thing for me is if you look at page 18, the reply to the subpoena sought to obtain evidence of these so-called Louis Vuitton bags. And the reply I got from IDAC to my lawyers was, quote unquote, "These are criminal matters that remain active, and IDAC cannot share any of the information and or documentation requested in paragraphs 1 to 4 of the subpoena." That's all the evidence I have. So it's not a smoking gun. You've got a newspaper article, an attempt by me to validate the newspaper article by issuing a subpoena, and IDAC's response saying, "This is a live investigation. I'm not giving you an answer to your subpoena." And commissioners, I'm saying, surely that gives the impression that there is something here. There's something going on with these Louis Vuitton bags.
Mr. Sullivan, can I ask you this question? In paragraph 1.6.2, you say this gentleman is alleged to have gifted. Do you know who makes these allegations? Do you know who the source of the allegations?
Say again, I didn't catch you.
Paragraph 1.6.2 on page 17 of your statement.
Yep.
The name of the gentleman is mentioned there, and
Mr.
you say,
Kistia.
yes, it is he's alleged to have gifted expensive
It's what's
bags.
in the article.
So you're relying on the article.
I'm relying on the article, and that's why I'm saying this is from the article. Mr. Kistia is alleged to have gifted these Louis Vuitton bags.
But you don't know who makes the allegations. You don't know who
If
the
you-
source is.
Commissioner, if you look at the article, it doesn't give a name.
No, I'm
in
asking
fact-
you, Mr. O'Sullivan, forget about the article. I'm asking you sitting here
Yeah.
today. Do you know who makes the allegations or who is the source that makes the allegations?
My understanding, and I've put it here in my statement, is that it was Brigadier Rass, a female brigadier who went on the journey with them. And that's on page 18.
Where he references annexures S1 and S2, Commissioner.
Yeah. So my understanding is that Brigadier Rass was also given a Louis Vuitton bag, but when she returned to South Africa, she handed it in because she said she didn't want it, because she knew that Inbanat and Kistia either was going to be charged or she knew that there was a corrupt relationship. Inbanat and Kistia is currently on trial with General Pashlani for corruption, involving vast sums of money, millions and millions.
I just wanted to make sure that you are not attributing to her things she did not say.
Yeah. Sorry?
Did she say that, or is that what you assume she said?
I received information that she was on that trip and she handed the bag in. I've never spoken to her.
Okay.
Okay?
Sorry, Mr. O'Sullivan. I'm looking at what Commissioner Khumalo just referred you to in paragraph 1.6.2.
1 point?
Where Commissioner Khumalo just referred you to, 1.6.2, the part that says, however, I was able to later confirm the allegations from a source. It seems a female brigadier, that's the brigadier you referred to. I think you gave a name just now, or not?
Correct.
Yes.
It's on the next page.
Yes, the brigadier was on the trip to Europe and also received a bag which she then handed to IDAC. I'm comparing that with what appears in the article that you say is your basis
That
for...
doesn't appear here.
Yeah, because at page 335, here's what the article says, the third paragraph at 335. I'm reading the last sentence. The two, that is General Masemola and General Mkwanazi.
So which paragraph?
The third paragraph at page 335.
Yes.
I'm reading the second sentence, which is the last sentence of that paragraph. It says the two returned home with luxurious bags while their colleague, I assume the colleague is the brigadier, or not?
So, Commissioner, in my opinion, this story is possibly slightly wrong, because my understanding is that the person that was snubbed wasn't snubbed, but also got a Louis Vuitton bag and brought it back to South Africa and handed it in with a sworn statement.
Oh, so that part of the article is wrong.
Pardon?
So that part of the article is wrong.
Yes.
Oh, all right. I just wanted to check that because you
That's
basically...
my understanding,
Yeah.
Commissioner. Yeah.
Can I just clarify from your response, the question and response by Commissioner Kumalo, and your reference to that Brigadier Ras, your statement as it reads does not say she reported General Masemola and Mkwanazi.
It
Is
says
that-
on paragraph 1.6.2, Commissioner, it says, however, I was able to later confirm the allegations from a source.
Yes.
It seems a female brigadier was on the trip to Europe and also received the bag, which she then handed to IDAC.
Yes, but that doesn't say she reported the two generals that they received a bag.
Yeah, I could have said together with a sworn statement, but my understanding is there was also a sworn statement.
Is your evidence that the brigadier submitted a sworn statement in which she states?
My understanding, so...
Yeah, let me finish for the record.
Yeah.
I do need to finish. My question is, and I just seek to clarify what you are saying. Is your evidence that Brigadier Ras, who you say also received a Louis Vuitton bag, she declared it to IDAC, or she reported it to IDAC, and she submitted a sworn statement. Are you saying in that sworn statement, she also states that the two generals, Masemola and Mkwanazi, also received Louis Vuitton bags? Is that what you're saying?
I wish I knew, Commissioner, but when I served the subpoena, this is what I sought clarity on.
Okay, so you haven't seen her statement?
No, I haven't seen it. If I'd seen it, you'd be seeing it now too.
Okay.
Because I wouldn't keep information from you. So, to be crystal clear, this, you could say, is just pure hearsay. However, it would be hearsay if I'd have got a feedback from my subpoena that said, listen, I don't know what you're talking about, get lost. That's not what I got. What I got back was, these are criminal matters that remain active, and IDAC cannot share any of the information or documentation requested in paragraphs 1 to 4 of the subpoena. And that tells me there's something going on here. And what I also noticed, and I mentioned it in my statement, is that nowhere in the evidence that he gave, either at the ad hoc committee or at this committee, General Mkwanazi specifically state, by the way, for the record, I've never received a Louis Vuitton bag. Instead, he makes throwaway comments such as, at least my wife now knows what a Louis Vuitton bag is valued at.
Okay, I haven't seen his evidence in the ad hoc committee. He will come back. He will come back to us and he'll speak to that. I just needed to clarify what I thought I had understood your evidence to be. Thank you.
And your source about the brigadier, was that a sub-source or not? I'm not asking for a name.
Yes, it was a SEP source.
Thank you.
Thank you, Commissioners. Mr. O'Sullivan, if we go to, you make the point at paragraph 1.6.3 regarding IDEC's response to your subpoena.
Correct.
And you suggest that their response and the manner in which it's couched, as you quote there, is what gives either credence to an allegation that there's something, what did you say, they smoke,
Yes.
I think, yeah. But I accept that. I would like us to look at your annexure R, and that is the article at page 334. At page 334, the last paragraph on that page, the article reads, and I quote, "In a case that resembles that of former top cop Jackie Silebi over a decade ago, Masemola and another former National Commissioner Mkwanazi were last week slapped with subpoenas by the investigating Directorate ID to explain why they failed to declare Louis Vuitton handbags they received from controversial Durban businessmen and sub-supplier in Banatan Kistia. Apologize if I mispronounced that. So that's what the article claims, that they were served with subpoenas. So would you accept, if the article is correct in that regard, IDEC's response would also be correct in saying that these are criminal matters that remain active in IDEC, if IDEC had issued a subpoena
Thank you.
conducting an investigation?
If you look at page 338
Yes,
of my evidence bundle,
yes.
it's that page of the subpoena. It's listing 4 items. 1, all ID/IDAC communications and/or subpoenas sent or served on Lieutenant General Mkwanazi and/or General Fani Masemola, asking them to. So this subpoena is based on that article. It's asking for this clarity. It's asking for any response received from IDAC. It's asking for a photograph certified as a photo of the Louis Vuitton bag currently in the evidence locker or evidence room of ID/IDAC. And finally, a certified copy of the sworn statement provided to ID/IDAC by the brigadier that attended on the overseas trip with General Mkwanazi and General Fani Masemola, in which she explains the receipt of the Louis Vuitton bag mentioned in 3 above. So the response tends to confirm inadvertently those issues.
But I'm not taking issue with that, I accept, and I say if we accept the correctness of the article, that IDEC issued subpoenas in respect of these bags.
It would appear to be
right?
the case.
Yes, and if we accept that that is potentially the case, then the response by IDEC has got to be appropriate, that these are part of ongoing investigations,
Yes.
and they are not in a position to share
Correct.
the requested information with you.
Correct, which is why I decided to raise it at the Commission.
And IDEC's response doesn't imply that the investigations have established as a fact. It simply mentions that the investigations are ongoing.
Correct.
Okay, thank you. And you have testified to the fact that General Mkwanazi's response is what you believe further lends credence to the claim, where you quote him as saying, "At least my wife now knows what a Louis Vuitton bag is valued at." And that's the sum total on which, that's all you can
The
put
point I
forward
was
at this
making,
point, yeah.
Commissioners, is that nowhere could I see him saying, by the way, for the record, I never received any Louis Vuitton bag. Instead, he gives this throwaway comment, at least my wife now knows what a Louis Vuitton bag is worth.
Is there anything else on that subtopic that you would like us to?
Nothing at all.
Okay, then staying still at page 18, that leads us to the next subtopic at 1.7, General Mkwanazi, political pressure, and Lieutenant General Mdluli. Now, this is quite an involved subtopic. You start at paragraph 1.7.2 by summarizing Annexure T, which is the affidavit at page 336, which is the affidavit. I think my numbering is No, not 336. I'll find the correct page for you.
345.
345, page
Yeah.
345. Thank you. Now you summarize this affidavit in detail over the next couple of pages.
Over the next 4 pages.
Over the next 4 pages, and you contrast that with the papers from the Freedom Under Law application
Yes.
that was launched
Yes.
to review and overturn General Mdluli's reinstatement following his suspension, correct?
Yes.
Can we try and summarize what the key issues arising from these two
Yes. And if I-
substantive documents are?
My
Can I-
summary,
Just a moment.
Sorry.
Can I ask that because you're going to summarize that we amend paragraph 1.7.2.11? So
Instead
on
of
page
2.2,
21, that
yes.
15 May should be 2012 and not 2021. 1.7.2.11 on page 21.
yes.
Are you there?
Yes, I'm there, yeah.
That 15 May date should be 2012, not 2021.
Yes.
Correct.
Well
Thank
spotted.
you, Commissioner.
Thank you.
Thank you. You may proceed, Mr. O'Sullivan.
Okay, thank you. First, I should thank the Commissioner. You know, this was typed very late at night. The essence of this can be found at paragraph 1.7.1.
If I may, I do beg your pardon.
Pardon?
I do beg your pardon for interrupting. Just to point out that your annexure T, that affidavit, General Mkwanazi has already submitted before the commission when he testified in September. Then commissioners, for the record, is MK22. So we have dealt with that affidavit before, and maybe in a slightly more cursory fashion. So it's not new to the commissioners, this affidavit.
Okay.
They've seen it before. Thanks.
So if I can take the Commissioners to page 18 of my statement, in particular paragraph 1.7.1. So in order to go forward, we have to go back a little bit. And what I'm saying here, if we go back to the media conference of the 6th of July, 2025, there were 2 central themes of General Mkwanazi's press conference. The one was organized crime's infiltration of the criminal justice system, and the other was political interference in the police by the Minister of Police. Those were the 2 central themes, and I think that's common cause. I've dealt with, in some detail, the examples of infiltration of the underworld into the police and the effect that has had on the police. And I've said it wasn't new. And I'm making the point here by saying, nor was political interference in the SAPS new. The irony of the latter fact is that during his period as acting National Commissioner in 2012, General Mkwanazi himself turned a blind eye to unlawful political interference relating to the then Divisional Commissioner of Crime Intelligence, Lieutenant General Richard Mdluli. In fact, General Mkwanazi not only turned a blind eye, but he also acquiesced to patently unlawful instructions, then later helped to cover it up. And that may be considered a very serious allegation. But the evidence I will present will actually bear out this allegation, Commissioners. And first of all, we start with this paragraph 1.7.2, which rambles on. And what it is, it's an analysis of Annexure T. And Annexure T is the self-same affidavit presented by General Mkwanazi to the State Capture Commission, and it's dated 29th of September 2020. Now, in that affidavit, he makes certain averments under oath. And what I've tried to do here is to capture those averments. In other words, to coin a phrase, explain what it is he was saying under oath. And I want, rather than read out every single one of those sub-paragraphs, I want to jump forward to page 20 of my affidavit and go to sub-paragraph 1.7.2.8. And the last 4 lines of that sub-paragraph states, quote, "Finally, under pressure from the Minister of Police at a meeting to which he called the Inspector General and General Mkwanazi, the Inspector General," this would be the Inspector General of Intelligence, Commissioners, "the Inspector General reinstated the opinion and recommendation. I cannot think of a more blatant demonstration of unlawful executive overreach." It's me saying that. And then I go on to 1.7.2.9. At the meeting with Minister Mtetwa, and this is based on his affidavit, at the meeting with Minister Mtetwa and the Inspector General of Intelligence, the Minister instructed General Mkwanazi to uplift the suspension of General Mdluli. General Mkwanazi later claims to have informed Minister Mtetwa at the meeting that his instruction was illegal. Nevertheless, he acquiesced. General Mkwanazi has always been deliberately vague about the dates and times of these meetings. Given the importance of same, there can be no legitimate reason for this vagueness. And then we continue on page 21. 1.7.2.10. Following the meeting with the Minister of Police and the unlawful reinstatement of the Inspector General's opinion, bearing in mind, according to his version of events, the Inspector General of Intelligence was like a straw in the wind, flip-flopping, 1 minute saying this and the next minute saying that, and then going back to the original. It says here, General Mkwanazi uplifted the suspension of General Mdluli on the 27th of March 2012, and he returned to work, where he was also handed the additional responsibility of protecting the President and ministers. So this whole division in the police, called the Security Division of the Police, which is the VIP protection units, was now suddenly handed over to the head, the divisional head of crime intelligence, which is Richard Mdluli. And then, on the 15th of May 2012, thank you, Commissioner, for pointing out the 1 and 2 being the wrong way round, after the Freedom Under Law application was launched, new disciplinary proceedings were instituted against General Mdluli, and on the 25th of May 2012, General Mkwanazi recanted his earlier decision and suspended General Mdluli again. Public pressure was building. At the start of June, General Mkwanazi met with President Zuma and appears to have been pressurized to withdraw the new disciplinary proceedings against General Mdluli and his suspension. This is based on his version of events. At the meeting, it was agreed that General Mkwanazi would not continue as acting National Commissioner beyond the few remaining weeks that were required to appoint a new National Commissioner, General Piega, with 0 policing experience, who, well, that's just my throwaway, was duly appointed on the 12th of June. So now suddenly, General Mkwanazi, who's been the acting Commissioner of Police since the prior year in September, is now suddenly no longer the acting Commissioner of Police. And then I go on to page 22. at 1.7.3, I say, on its own terms, the narrative of General Mkwanazi shows that he readily succumbed to political pressure and implemented the illegal instruction of the minister to uplift the suspension of General Mdluli, whilst all material times knowing that this instruction was illegal. How do we know, Commissioners, that at all material times he knew the instruction was illegal? Because he says so under oath in 2020. But here's the best part. When he enacted this unlawful instruction in 2012, he was invited to Parliament, and on the 19th of April, he was asked at Parliament why he had uplifted the suspension of General Mdluli and put him back to work. And his answer was short and sweet. He said, "I acted according to higher authority." And when he was asked what the higher authority was, he declined to say. On the 15th of May, when the Freedom Under Law application was launched, there were two sections to it, a Part A for urgent relief and a Part B, which was a confirmatory of the urgent relief. And the urgent relief that Freedom Under Law requested, and I've got all the pleadings, the urgent relief that Freedom Under Law requested was that the decision of General Mkwanazi was to be declared unlawful and invalid, and that General Mdluli was to be put back on suspension and removed from doing its police work. Now, that Part A application was launched on the 15th of June. It was an urgent application. General Mkwanazi supplied the answering affidavit. And in the answering affidavit, he doesn't deny that he was acting on a higher authority. In fact, he keeps quiet about it. He keeps quiet about it for 8 years and only comes out with it in 2020. So from 2012 to 2020, nobody in the country knew that he had acted on the unlawful instruction of the then Minister of Police, Nathi Mthethwa. And that is the point I'm making here. So then I say at 1.7.4 on page 22, when regard is had to the facts of the Freedom Under Law application, General Mkwanazi's collusion with the illegal interference of the Minister and the President is even more stark. The chronology of the Freedom Under Law matter is the following, and I set out the chronology. And at 1.7.5 I say the following. There are two noticeable aspects of General Mkwanazi's conduct in relation to the Freedom Under Law litigation that show he assisted to cover up the executive interference in the SAPs, which he knew to be unlawful. 1.7.5.2. First, in the face of the founding affidavit from Freedom Under Law that specifically alleged executive interference in an attempt to pressurize him to withdraw the disciplinary action against General Mdluli and his suspension, General Mkwanazi did not admit the relevant facts. Instead, he deposed to an affidavit which did not respond to the allegations, but nevertheless opposed, on spurious grounds, the urgent interdict sought to prevent General Mdluli from executing police functions. And this is found at page, the evidence here, Commissioners, I refer to paragraph 49 of the Supreme Court of Appeal judgment, and paragraph 211 of the High Court judgment. Now, if you go to page 437 of the evidence bundle, you will see that I have highlighted a number of paragraphs because it's quite a lengthy judgment. But if you look at page 437 at paragraph 211, this is now the full application. So what you had was a Part A and a Part B. And the Part A was heard by Justice Makhoba J, expressed And it says here, in paragraph 14 of the judgment in the Part A proceedings, Makhoba J expressed concern about the allegations of political interference in the disciplinary process and noted that Mkwanazi had not disputed them in his answering affidavit. Now, if you go back to go forward to page 469, which is in the Supreme Court of Appeal, page 469 at paragraph 49. This is now the Supreme Court of Appeal judgment. At paragraph 49, Commissioners, it states, as a factual basis for the challenge of these decisions, Freedom Under Law relied in its founding affidavit on a statement by the then acting Commissioner, Lieutenant General Mkwanazi, in Parliament that he was instructed by authorities, quote unquote, beyond him to withdraw disciplinary charges and reinstate Mdluli in his office. Freedom Under Law added that in doing so, Mkwanazi had failed to make an independent decision, which rendered his actions reviewable. Though Mkwanazi filed an answering affidavit in the interim interdict proceedings in Part A of the Notice of Motion, he did not deal with these allegations. So you had this situation where General Mkwanazi is facing litigation based on his conduct to unlawfully act on the instructions of the Minister of Police. And what's the relevance of all this, you may ask? Well, his complaint on the 6th of July last year had two legs to it. One was criminal interference or penetration of the police, and the second leg was the executive overreach, the ministerial interference in the management of the police, which is exactly what happened in 2012, and he was a party to it, and not only was he a party to it, he helped cover it up for the better part of 8 years. And only in 2020 does he come out with it.
Yes. Mr. O'Sullivan, I'm just trying to understand the import of your evidence. Are you saying, because of what you describe as his past conduct, are you saying he should not have spoken up in July, he should not have complained about political interference?
Commissioner, what I'm saying is, you can't change history. He did what he did.
Yes.
But what he didn't do when he came to this commission, he didn't take the commission into his confidence and say, by the way, although I'm speaking out about it now, I just want to inform you that 14 years ago, I was engaged in just the same activity.
So is the criticism, I'm trying to understand, as I say, the import. What are we to do with this evidence that you obviously consider to be important to mention? Are you saying because according to you, he was complicit, and at this point I'm not dealing with whether or not what you're saying he did previously is correct. I'm asking if you're criticizing, as I understand, and please correct me, if you're I understand you to be criticizing him for, on the 6th of July, mentioning or complaining about overreach, political overreach or political interference. I understand you to be criticizing him for that. And I'm trying to understand, are you saying, with that criticism, are you saying he should not have spoken as he did about this aspect of things? This second, you say there are two legs to it.
Well, it's hard to come to a informed answer there, other than to say that was I not to produce this evidence here now, this commission would be completely unaware of the fact that the conduct he's now complaining of was exactly the conduct that he was involved in some years back. And if you're going to be a whistleblower, as he claims to be, you should be a whistleblower with clean hands.
Yeah, exactly my confusion. That's why I'm asking you this question, exactly my confusion. Are you saying he is not a clean whistleblower according to you, because
Correct.
he previously colluded in similar conduct. Therefore, he should not have spoken up. Is that the heart of what you're saying? And maybe let me suggest to you that I ask the question because it's quite conceivable that someone thinks about it this way. The man had a Damascus moment. He previously colluded, according to you, and then come July 2025, he decides not anymore, and he changes his mind. I'm asking from that perspective,
Yeah.
Are you saying he should have kept quiet forever?
Yeah.
Or the other possibilities you are saying, well, because he's got this past conduct, we should disregard his complaint of 2025 and disregard it to the end that he's talking, sorry, I can't think of a better word, he's talking nonsense, there was no political interference in 2025. Is that the point you're making?
So my understanding, Commissioner, and you might have to interrogate me a bit further, but my understanding is quite simply this. If you're going to have a Damascus moment, put that down in writing. Say, look here, by the way, I'm speaking out now because I saw what happened all these years ago. And I was involved, but he didn't do that. He's kept quiet.
Yeah.
And therefore, I think it would have been better, rather than speak out at a media conference, to take action without drawing down the public confidence in the criminal justice system, because it's been shattering what's happened in the criminal justice system.
Okay, I guess I've asked my question and you've answered the way you did. I'll accept that's your best answer. The second issue about it, you've referred us to these judgments. And let's start with at 437, page 437, which is Makhoba J's judgment. Are you saying by not, because remember you've highlighted the part and you've read out where the judge says in his answering affidavit.
Sorry, ma'am, if I can just ask the paragraph number?
Looking at page 437?
Yeah,
And then-
437.
And then I'm looking, you referred to paragraph 211.
Uh-huh.
And you read there where the judge says, Mkwanazi had not disputed, maybe let me start at the beginning. It says, in paragraph 14 of his judgment, Makhoba J, well, I think this is the SCA judgment, in fact, you're referring to. Makhoba J expressed concern about the allegations of political interference in the disciplinary process and noted that Mkwanazi had not disputed them in his answering affidavit. What are you saying there about the conduct of General Mkwanazi?
What
Yeah.
I'm saying here, Commissioner, it's not me saying it, it's the High Court. And it's a scathing judgment against, this is what's referred to as the Murphy judgment. And it's a scathing judgment against the police
Yes.
and against, in particular, General Pieka and General Mkwanazi, against both of them. And this judgment hasn't seen the light of day for probably 10 years or more.
Yes. I'm asking the simple question because, you know, another construction, and I think in our practice that is accepted, is if you do not answer to a specific allegation, you have admitted it. So when I read 211, I would have concluded, until you spoke, I would have concluded, well, it means he didn't dispute it. He didn't dispute that there was political interference. But you seem to be reading that paragraph or to be attaching a meaning to it, that he basically was part of the cover-up, unless by not responding or not denying the allegation of ministerial interference, he therefore covered up, unless I misunderstand you, Mr. O'Sullivan?
Commissioner, you have to look at all the bits that I've highlighted and take them together. But if I go to page 438,
Yes.
at paragraph 215, 216, and 217, and 218,
Yes.
This is scathing. It says Mkwanazi dropped the disciplinary charges on orders from above is furthermore borne out by the Rule 53 record filed on his behalf. The record he supplied comprises nothing more than 2 letters addressed to Mdluli, one notifying him of the withdrawal of the disciplinary charges against him and the other advising him of his reinstatement to work. It doesn't say to work. There is no charge sheet or correspondence dealing with blah, 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 and it goes on. And then 216, it says, the inescapable finding is that the decision of the acting commissioner to withdraw the disciplinary charges and to reinstate Mdluli as head of crime intelligence were taken in an attitude of subservience pursuant to an unlawful dictation from a person unknown.
Yes.
Who was beyond the acting commissioner. By the way, at this stage, nobody would admit who it was that gave him the instruction. That only came 8 years later. He says, an abdication of power violates the principle that the responsibility for discretionary power rests with the authorized body and no one else. And it goes on to say at 218, to ensure the proper functioning of the SAPS, the Commissioner, in discharging his obligations under Section 11 of the SAPS Act, must protect and give effect to SLAP's discipline regulations. It's a scathing judgment. And the failure, it's not the judgment that's more important, Commissioners. What's more important to the people of this country is that this has been kept hidden. It's been kept under wraps. It should have been part of the evidence. He said, by the way, the reason I did what I did on the 6th of July is because 14 years ago, I was involved in exactly the same state of affairs, and I went along with it and covered it up for 8 years.
I guess, Mr. O'Sullivan, my question is, what difference does it make? Remember, we consider our terms of reference. I don't know that we can take it any further, but really my question is, even if you are correct in your position that when he testified here, he should have confessed his previous sin of covering up, as you say.
Yes.
I'm still left with the question, okay, what difference does it make to, he has spoken up. We are investigating exactly that as a commission, whether indeed there's been political interference. Does it really make a difference that, and if so, what difference does it make to how we deal with that allegation of his, that when he sat there and testified, he didn't testify to his previous crime of colluding in the similar decision-making that he's now complaining about?
Well, except, Commissioner, it's my evidence that not only was he previously involved in that conduct, but for 8 years he covered it up. For 8 whole years. And it only came out when he made his statement at the Zondo Commission. And when he made his statement at the Zondo Commission, he did not go into the nitty-gritty of what actually took place. He gave a version of events, and I obviously have no first-hand knowledge as to whether or not the then Minister of Police in 2024 or 2025 did engage in executive overreach. I have no knowledge of that. It's not something I've been involved in. But if a person is going to become a whistleblower, surely that whistleblower is going to say, by the way, the reason I'm whistleblowing is because I was involved in this conduct 14 years ago and I saw the effect of it.
Thank you.
Thank you.
Thank you, Commissioner Baloyi. If I understand your summaries of both General Mkwanazi's affidavit before the Zondo Commission and the Freedom Under Law application, that application was brought in 2 parts, the interim relief in Part A and the main relief, the review in Part B. General Mkwanazi deposed to the affidavit in Part A, and I think you make the point in your statement that by the time Part B came around, General Pierre was deposing to that affidavit. So when you charge General Mkwanazi of failure to disclose, that he would be required to do in Part B, when by then he had already been transferred or to another department and General Pierre had taken his position. Do I understand you correctly?
Then I would point the commissioners at page 25, paragraph 1.7.9
Yes.
and 1.7.10, which I
Yes.
would like to read out.
Okay.
This is my testimony. Accordingly, even after he was fully aware of the contents of General Pieka's affidavits in the freedom under law proceedings, General Mkwanazi continued to cover up the illegal instruction he'd been given by Minister Ntetwa and the political interference of both Minister Ntetwa and President Zuma in decisions that he ought to have been able to take, free of any political interference. He could have, at that time, and indeed should have, approached the court with the truth. He failed to do so. He only finally came partly clean when he was interviewed by the investigators at the State Capture Commission, led by Justice Sondo. Even then, his version was a cover-up of the truth, and he fobbed them off by blaming others. Given General Mkwanazi's own collusion in an illegal process of political interference designed to keep General Mdluli in charge of the Division of Crime Intelligence and its regularly stolen secret funds, it is difficult to take seriously his complaints of political interference that he made in his infamous speech on the 6th of July 2025. In fact, General Mkwanazi's own unlawful conduct in 2011/12 make the current complaint he has made pale into insignificance while still sharing commonalities. For example, in 2011-12, General Mkwanazi's conduct was intended to unlawfully protect Crime Intelligence Divisional Head, much the same as his conduct in 2025 is intended to protect the Crime Intelligence Divisional Head and those under him.
If I just take a step back to your paragraph 1.7.9, just to clarify something.
Sorry, just catch that paragraph?
Page 25, paragraph 1.7.9. You state, and this is in response to the point I had raised with you, that the answering affidavit in the review application was deposed to by General Pierre, who had assumed that position by then.
Correct.
You state that even after he, General Mkwanazi, was fully aware of the contents of General Pierre's affidavits in the full proceedings, General Mkwanazi continued to cover up the illegal instruction he had been given by Minister Mtetwa.
Correct.
Now, what form did this cover-up take? On what basis do you say he continued? Firstly, he covered up, and secondly, that he continued to cover up. Thank you.
Maintaining silence. Because what happened, commissioners, while that period between Richard Mdluli being suspended and then having a suspension uplifted and then having a suspension reinstated and the court case is going on, during that period, the whole thing was argued out in court. And when it was argued out in court, it was all over the media. And the Supreme Court of Appeal go into some detail about how General Pierre misled the High Court. And General Mkwanazi kept quiet. He had a duty. He could not ignore that duty. And that duty was to step forward and say, well, hang on a minute. Actually, General Pierre's version of events is not true.
Was he a party to this application?
I'm saying he was. And the reason I say he was is contained within Annexure W.
And Annexure W.
Annexure W.
Page 475, That's where it starts.
Yes. If you have a look at page 14 of Annexure W, which is page, just bear with me a second. I'm going to have to count the pages. 1, 2.
If you perhaps give a sense of what you are looking for, we might try and assist.
14. Aha. Here we go. It's page 488 of the evidence bundle.
488.
488 of the evidence bundle.
Thank you.
So this is a presentation that was made on the 13th of November 2015 by the Minister of Police.
Yes.
It was, in fact, Mr. Mkwanazi was the Minister of Police then. This was a presentation by the Minister of Police to Parliament. And it's been uplifted from the parliamentary monitoring group thing. So this was made on the 15th of November, 13th of November.
It speaks of a grievance. It doesn't speak anything about, it's not answering
No,
my
but
question.
what it's showing, Commissioner, is that Lieutenant General Mkwanazi lodged a grievance against the National Commissioner for lodging false affidavits in court regarding Lieutenant General Mdlulu's case. And the point I'm trying to make is this corroborates the fact that other than lodging a grievance, he did nothing about it. He allowed her to lie to the court.
But that grievance has a finding as well further on in the, on the same page. The first point speaks to the grievance lodged by General Mkwanazi. Then there is a finding.
Yep.
And the finding says the
Finding says the National Commissioner informed the court wrongly with regard to Lieutenant General Mkwanazi's actions on Mdlulu matter. So what she actually did, what General Pieka did, was she informed the court, and that's borne out in the judgment. She wrongly informed the court that General Mkwanazi had not received instructions from a higher authority. She said that was a misunderstanding, and I'm going to supply a confirmatory affidavit from General Mkwanazi. It was never supplied. There was no, and even when it went to the Supreme Court of Appeal, they still couldn't supply a confirmatory affidavit. So the whole thing was hushed up. And what I'm saying, Commissioners, is if there was going to be any transparency here, it should have been a sworn affidavit by General Mkwanazi informing the court and opening a docket against General Pieka for lying to the court, which in effect, apart from being perjury, is the offence of defeating the ends of justice. And no such event ever took place.
I think my point is he wasn't a party to these proceedings, so he didn't have standing to file any affidavit. That's my point.
He wasn't a party, but he knew what was going on.
Yeah, but he wasn't a party. My question was he a party? And you said yes, and you referred us to this document.
He was a party to the original proceedings.
Yes.
The Part A.
Where you are saying he should have filed an affidavit. I'm saying he wasn't a party to those proceedings where now General Pieka is the party that is being sued. So he wasn't a party. You understand what I'm saying?
I understand you.
Yes. I think that's the first point. The second point, in the judgment, in the Murphy judgment, and this I think we accept it was in 2012. I think it was in 2013.
Say again?
In 2013, that's the Murphy judgment, right?
Yes, yes.
And it states at I'll read it for you.
What's the page number?
Page 436. And this is about the point of you saying he didn't speak up for a whole 28 years, I think you say. and spoke up for the first time in 2020 before the so-called Zondo Commission. And I'm reading this just to say it seems to suggest differently from what you're saying. At page 436, paragraph 207, it says, in paragraph 45 of the founding affidavit, FUL alleged that the acting commissioner publicly stated in Parliament that he took the decision to withdraw the disciplinary charges on instructions from authorities beyond him. And then Full added that by acting on the instructions of authorities beyond him, the acting commissioner failed to act independently. So it seems that at least Full, FUL, was aware when they filed their papers that he has spoken publicly, that
In fact-
the decision, let me finish.
Yeah, sorry.
That the decision that he took was imposed on him from higher authority. So why do you say that he kept this quiet until only in 2020?
Because at the parliamentary committee, it was asked what higher authority. He couldn't answer. He should have said the Minister of Police instructed me. Instead, he covered the thing up.
So the criticism is he didn't state it's
He
the
didn't state-
minister.
In fact, what happened, if you look at General Piecha's conduct in the FUL response, she said, actually, what he said at Parliament wasn't correct.
Yes.
He made a mistake. What he actually meant was the NPA had decided to withdraw the charges, and that's why he followed suit. The whole thing was a complete lie.
Okay. So that's Piecha. For now, I was just clarifying.
Yes.
I was clarifying that when the FUL prepared its answering affidavit,
Yes.
General Mkwanazi had already said in Parliament that he made the decision on higher authority, or it was dictated by higher authority. And your criticism, and I hear you.
They couldn't get
you
it
say
out of him.
Your
Parliament
criticism is he didn't say the higher authority is the minister.
That's what he
your
should have said.
Okay, thank you. Thanks, Mr.
Thank you.
Just one issue with you, Mr. Sullivan. Going back to page 488.
Page?
488. Remember, throughout this section of your affidavit, the point you sought to make was that General Mkwanazi has kept quiet for 8 years about the political interference that took place when he was acting national commissioner. Doesn't that paragraph in 1, the bullet point that sets out the grievance that he lodged in 2015, undermine that argument? Because it shows that as far back as 2015, he spoke about the fact that General Piecha misled the court in relation to the Mdluli matter. And then it ties up with what Commissioner Baloyi says, that even prior to that, he had said in Parliament that there was interference. Although he did not say who interfered, but at the very least, he did say there was interference.
I hear you, Commissioner.
So you cannot then, in those circumstances, say for 8 years he did not say anything, because what this presentation at least shows is that when he became aware that General Piecha may have misled the court, he lodged a grievance against her on the very Mdluli matter, so on the subject of the very issue that we are discussing. The detail may not have been there, and because you were not part of the presentation, maybe you would have expected more detail, but it's not correct to say there was complete silence for 8 years. That's the point I'm trying to make with you. That at the very least, there was something, not the detail that you expected.
There was something, Commissioner, but there wasn't transparency. What there was a complaint against Piecha for not telling the truth. But there wasn't, by the way, she wasn't truthful. What she should have said was bang, bang, bang.
Yes.
He didn't do that.
But he goes
it
a
covered
step further
up.
and he says he was not even consulted when the affidavits were prepared. The point being that if he was consulted, he would have stated the true facts.
Well, except for the fact that when he made the first affidavit, in the Part A, he kept quiet about the matter. If you look at the pleadings on the FUL matter, on the Freedom Under Law matter, they make it crystal clear that their pleadings, their application is based on the statement he made in Parliament on the 19th of April, where he stated to Parliament, when they said to him, why have you put this man back to job? Why have you lifted the charges against him? He said, I've acted on the basis of a higher authority. And they asked who? He refused to tell them. He couldn't tell them. So I'm saying he covered it up all the way along. And what that cover up comprised of, yes, you can say that this complaint, which was a grievance, there should have been a sworn affidavit stating the chapter and verse. It only came out in 2020. And please listen to this very carefully. What he stated to the Zondo Commission in 2020 was not chapter and verse. What he should have done was given a blow-by-blow, where the meetings took place, when they took place, the dates and times and everything. He didn't. The thing was kept vague. And I'm saying it was deliberately kept vague.
But in the affidavit before the Zondo Commission, he does mention the days of the meetings. If you go to 376,
376. Yep.
And that's the affidavit before the Zondo Commission.
Correct.
You will see that he mentions the meetings, he mentions the
Are you
dates.
paragraph number, sorry?
The dates of the letters.
Yes, that's referring to dates of letters.
Yes.
But the information that's missing, Commissioner, is the dates of the meeting in respect of the police minister. That meeting date has been kept vague. There's no date there.
Yes. But we know that it is March because the letters are the March letters. So when he refers to the IG opinion that was first issued and then was later withdrawn, so he's referring to the March date, and that much is clear from paragraph 48 on page 356, that we are in the March period because we know that the meeting with President Zuma happens in June. So although it doesn't specify the date of the meeting, but it's quite clear that the date is between the
somewhere around then.
It's between the two opinions by the Inspector General. So
yeah.
It would have been between the 6th of March and the 19th of March. That's at least how I read paragraph 48, that the meeting would have happened between those two dates.
Commissioner Khumalo, perhaps what might assist is reference to page 363.
Yes.
At the bottom of 363 is paragraph 39. That gives a date on 23rd April 2012, Lieutenant Drummond authored a further letter. This is in the sequence when he's narrating sequence of events.
Sorry, page?
It's paragraph 39.
Sorry, what page number?
Sorry, I was looking at the wrong version of the document, but it's paragraph 39.
372.
If you go then from 372, paragraph 39, that's where he introduces the date, the letter by Lieutenant General Dramat of 23rd April 2012. And then at 40, he quotes that letter. And then at paragraph 42 under heading H, interference by Minister of Police. It says, a few days after my conversation with Advocate Khadebe, I chaired this meeting at the police headquarters, and he continues. So if one were to follow his timelines, it would give you a good sense of when the meeting, although admittedly it's not dated, took place. Would you have a challenge, a difficulty with that?
Commissioners, the only difficulty I have with that is that if it's such an important meeting, why don't we have a date for the meeting and a time for the meeting that says, on this day at this time, the following meeting took place? I'm just saying that's the way I see it.
Okay.
It could well be that he's happy with keeping it vague. I'm not happy with keeping it vague.
That's why I was saying your issue is not so much that he did not disclose what happened. Your issue is that he did not give the full detail, including the date.
Yeah, when he disclosed it on the 2020 affidavit, in the 8 years preceding that, he had an opportunity to come out and say, by the way, on this date, at this time, I had a meeting with the Minister of Police, who unlawfully instructed me. The only time this comes out is here, 8 years later. It never came out before then. Never. Thank you.
On that score, then, may I invite us to go to your page 23 of your statement?
Page
Page 23.
22.
23.
Uh-huh.
And paragraph 1.7.5.3, you actually make a much stronger allegation against General Mkwanazi. You say, second, he appears to have colluded in allowing SAPS to put a dishonest version in their answering affidavit to Part B to the court.
Yep.
When then Commissioner Pierre falsely stated that there had been no instruction to General Mkwanazi from above.
Yeah. And the reason I'm saying that,
My question is, what must the commissioners look to see the collusion that you reference?
because at that time, we have to cast our minds back to 2012. So during that whole period, there was a lot of media coverage. Major General Richard Ndluli, or Lieutenant General, Richard Ndluli, was in the media every single week, 2 or 3 times a week. This whole thing, as it was being played out in court, was all over the media. Now, by his own account, he spent 2 years sitting at home twiddling his thumbs during that period, while General Pierre went out and gave a complete pack of lies to the court, which was published. It was all over the media. I'm saying, if I know about something that's wrong and I keep quiet, I'm assisting in the cover-up. And that's the point I'm trying to make. And if you go through the documentation, if you go through the judgments, and you look in May 2012, and the Murphy judgment, still nothing. He only comes out with it for the first time 8 years later. Why keep quiet? Keeping quiet for 8 years, I'm saying, is acquiescing to crime.
I think, Mr. O'Sullivan, it's one thing to say, by keeping quiet, he acquiesced in a lie that he knew about. So firstly, you have to establish he knew that General Pierre in her affidavit has said this, and he chose to keep quiet. So you have to establish that fact first. And I don't know that you have said enough in your testimony that indicates he knew, as a matter of fact, not what you say. He was at home for 2 years, it was playing out in the media, he should have been aware of it. It seems to me that you would first have to establish that he knew, as a matter of fact, indisputable fact, that this was said in the affidavit, and knowing that he made the decision to keep quiet. That's one thing. But if to say that he colluded, and perhaps in fact he does collude if he does that on those facts, if he knew and he chose to keep quiet, he colludes by omission. That's the one form in which he could have colluded. The alternative formulation is he was deliberate. He was part of the cover-up. It's not a case of omission, but it was deliberate. So in a way, it was by commission, right? He knew this is happening, and he chose to be part of that lie. I don't know that beyond your, whether you can put it as high as that, and yet your statement here where you say appears to have colluded in allowing the subs. I'm not sure that it is backed up by anything that you have said. We've gone through a number of instances where he has said and spoken, including up to the grievance that he laid against General Pierre. And in all of that, I haven't seen, I must say, speaking for myself, that I don't see the positive and intentional act that you're seeking to convey in 1753, that he intentionally participated in a General Pierre cover-up.
Okay, I hear what you're saying, Commissioner, and I'd like to draw your attention to what I say at paragraph 1.7.6. Because I'm saying there, in contrast, General Mkwanazi claims in his affidavit to the State Capture Commission that he was completely unaware of the contents of General Pierre's affidavit. I'm saying I find that claim in that affidavit unconvincing. And the reason I find it unconvincing is because he had made a grievance against her for being untruthful in her answering affidavit to the High Court. And I go on to say, General Mkwanazi therefore knew that the allegation of an unlawful instruction to him was at the centre of the application. And the reply from General Pierre would have to admit that central allegation if she was not going to perjure herself.
Thank you.
Sorry. Mr. O'Sullivan, you give two reasons for what you have just said now. You say, in contrast, General Mkwanazi claims in his affidavit to the State Capture Commission that he was completely unaware of the contents of General Pierre's affidavit because he was in his period of rest at home in KwaZulu-Natal at the time. I find this claim unconvincing because, and then comes the two reasons,
Yes.
or then come, not comes, the two reasons that you give.
Yes.
Even if I take a bit of time, I will read both. The first one is this. General Mkwanazi was aware of the allegations in the FUL application because the founding affidavit in the agent application had been served on subs whilst he was acting National Commissioner, and he had deposed to the initial answer in that application, but chose to sidestep the unlawful instruction allegation and simply not comment. General Mkwanazi, therefore, knew that the allegation of an unlawful instruction to him was at the center of the application, and the reply from General Pierre would have to admit to that central allegation if she was not going to perjure herself. Let's focus on that reason and not overlap onto the second reason. Yes.
Of course, you can read different things into it,
Yeah.
the way I phrased it.
On what basis would you want to suggest that General Mkwanazi would have known what General Pierre would say or not say in her answering affidavit on the Part B of the application, going so far as to talk about perjury and so on?
My argument, Commissioner, is very simple. I go to Minister Nshleko's presentation in 2015 to the Parliamentary Portfolio Committee on Police, where he talks about the grievance. And he didn't make the grievance in 2015, he made it earlier than that. So here he was making a grievance about the alleged perjury of General Pierre. But what he wasn't doing was saying it's perjury because this is what really happened. He just said she perjured herself.
But here you are talking about what General Mkwanazi ought to have known what General Pierre would say not what she had in fact said. What she would say in deposing to the Part B answering affidavit.
He would have post factum. He only knew about it after.
So those are two different things. What may have happened a couple of years later does not answer what General Mkwanazi should have known with regard to what General Piecha would say in her Part B answering affidavit. That's where I am.
So, yes, Commissioner, but the point I'm making is he knew what the central allegation of the freedom under law application was. He knew. The whole application was
Yes.
found on this allegation that he had received unlawful instructions.
But what's going to be deposed to is not his affidavit. And if nobody invites him to come depose to the affidavit as the person who actually knew what had happened, then on what basis can you fault him with regard to what the content of Gerald Piecha's affidavit was going to be?
Let me give you an analogy, Commissioner.
Yes.
If you look at Section 34 of PRECA, the Prevention and Combating of Corrupt Activities Act, it makes it an offence for a person not to report a particular category of crime. We're talking here about the previous acting commissioner of police, who is now sitting at home twiddling his thumbs, watching all the media coverage. I cannot believe he wasn't able to see what was going on in the media. And instead of stepping up and saying, well, hang on a minute, this is not true, he kept quiet. And the point I'm making is he had ample opportunity to not keep quiet, and he didn't do so. And he was a policeman.
I know right at the beginning of this engagement, I said that we should not conflate the two reasons that you give, and I'm going to preach exactly what I had said to you. You see, the difficulty I have with what you have just said about not believing that he would not have become aware of what the media was saying. In your second reason, you actually accept the possibility that he might not have become aware of what was out there in the media. You go so far as to say that, but if he had himself not become aware, people close to him would surely have told him. So in answering my question with regard to the first reason, I do not think you can peg your answer on him having heard or seen or read what was out there in the media.
Well, of course.
Because then you are contradicting yourself.
No, of course. If the commission gives him the benefit of the doubt.
You first gave him the benefit of the doubt.
I don't necessarily, I'm saying I wasn't convinced by his argument.
Yes.
Okay? And the reason I wasn't convinced of his 2020 affidavit was because in 2015, he was moaning and grievance about Commissioner Piecha lying under oath against him. About him, that he didn't say this, and therefore, he was never offered a confirmatory statement. At the end of the day, Commissioner, what it boils down to, from me as an evidence giver, is it's I suppose, 80% gut feeling. But if you look at the reality of it, there's no evidence between 2012, when he had an opportunity to come clean, when he made the first answering affidavit to the Part A, he had an opportunity to come clean and tell the truth. He kept quiet. And the first time we hear about it was at the State Capture Commission, and that comes out in his affidavit. And it really then is utilized at this commission. But what he doesn't do at this commission is said, by the way, I kept quiet about it for 8 years. I told the State Capture Commission, I just think it should have been a lot more transparent. If we are talking about a junior policeman, I can understand, but we are talking about a person who was the acting commissioner of police. He was in charge of running the police service, and he was the man, nobody else, him. He was the one that unlawfully put Richard Ndluli back to work, forcing civil society to bring urgent applications to get Richard Ndluli back out from his office. And I'm going to paint in my closing argument or whatever you want to call it, the reality between that and what went on at the 6th of July media conference, because there are similarities here.
Yeah, those are related issues I will immediately accept. But you are dealing with something specific here, which is about why, and you keep repeating the words, he was sitting at home twiddling his fingers. I will not go so far as to say he was twiddling his fingers, but you repeatedly refer to the fact that he was sitting at home. And your point is more that he had all the time to basically anticipate whatever it is General Pierre would say about this, lest she perjure herself. That's the substance of the question. I accept the other issues that you've just referred to in response to my question are related, but they are not really what you are addressing in 1.7.6.2. So that is, my point is, this is somebody who is sitting at home under the circumstances that we all know, based on the testimony or the material before us. Now, on what basis must he insert himself and say, I'm lifting my hand, here I am, just in case the current incumbent, General Pierre, might perjure herself, I'm offering myself. Why should he have done that? Shouldn't those who were preparing the answer, the Part B answering affidavit, have been the ones who approach him specifically and say, you are the person best placed to answer this, therefore, please tell us what you know so that we file your affidavit as a confirmatory affidavit to what General Pierre is going to be saying?
Well, it's a tricky one, Commissioner. The reality of the situation is that during that period of time, President Zuma was running the country, or running the government, and we had all these things going on. And I cannot say beyond reasonable doubt that he colluded. But what I can say is he would have known that in order for her answering affidavit to be truthful, she would have had to say that which he refused to say, which is that he got an instruction, according to his version of events later, from the Commissioner, from the Minister of Police to reappoint General Mkwanazi. And let's give him the benefit of the doubt and say he wasn't listening to what's going on in the media. Let's just say that he was blind to all these things that were going on. But somehow he was able to make a complaint, a grievance. If I was in his shoes, I would have been beating a path to the door to say, hang on a minute, let's tell the truth here. But he couldn't. And the reason he couldn't was because it was still too short a period after the event where he had acted unlawfully by carrying out the instructions of the Minister of Police. But 8 years later, you know, time has passed, water has gone under the bridge, now we can put it out there. I believe he should have put it out there a lot sooner.
Let's move on to the second reason, 1.7.6.3. I don't think we have much to say there because I already touched on it when we were dealing with the first one. But the point I will make in this regard is that doesn't your second reason become attenuated in the sense that you yourself already accept the possibility that he might not have seen, that is General Mkwanazi, he might not have seen what was out there in the media?
Well, that possibility, you can say, exists there. But then I counter it by saying, even if he wasn't aware of the news coverage, it's inconceivable that none of his close colleagues in the police would have drawn General Pierre's denial to his attention. And the reality is, he became aware of it somehow because he laid a grievance.
That's speculation of the highest order. We are talking as at the time. I'm
Yeah.
engaging you as at the time. That's speculation of the highest order.
It's hard to say.
Yes,
The time machine, I guess, would be needed.
yes. Thank you, thank you.
Thank you, Chair. Maybe for my understanding, can we go to page 384? 384 of the bundle, and that we are still in General Mkwanazi's affidavit to the Commission, to the State Capture Commission.
384.
384.
Yep.
And he starts at paragraph 67, that on those dates, 17, 18, 19 of April 2012, they appeared before the Portfolio Committee. I'm interested in what's set out in paragraph 69, where he says, having presented, he concluded with the remarks, other powers decided on convictions, not just the SAPs. Here I was referring to where matters were taken out of control of the police. Is it that quotation that you say means where he's supposed to have said to Parliament that he acted on at the behest of other powers?
Yeah.
Or is it a completely different engagement on that score?
My understanding, Commissioners, is that there he's talking about the criminal charges, not the disciplinary charges. So the criminal charges were not in his domain. They're in the domain of the NPA. And as we know, that was being mismanaged by advocates Mwebi and Jiba. So I opened, by the way, a criminal complaint against them for the mismanagement of that whole mess. So you have this situation where the National Prosecuting Authority under advocates, by the way, at that stage, Advocate Jiba was the acting NDPP. And then Advocate Mwebi, Lawrence Mwebi, was the head, the national head of
Yes.
commercial crime at the NPA. And they took an unlawful decision to withdraw the criminal charges, not only the charges pertaining to the kidnap and murder of his wife's ex-boyfriend or whatever the case may be, but also the alleged fraud and corruption charges. They took those decisions unlawfully, and I believe that's what he's talking about here.
And that's the clarity I was seeking, whether what he states at paragraph 69. So you are saying when he says he stated to Parliament that other powers decided on convictions, not just the subs.
Yeah.
He was referring to the criminal case. It
The
has got
criminal
nothing
case,
to
but
do.
what he doesn't say, Commissioners, is he doesn't say what he said about the disciplinary charges, because that's what he was questioned on in Parliament. And he said a higher authority, that's his words. And when they tried to drill down into that, he said he couldn't go into it.
I accept. I just needed your clarity on this, that quotation I read there, I should not misunderstand as his response to the issue of withdrawal of the disciplinary charges. I should not misunderstand that quotation to relate to that.
I believe this is not to do with the disciplinary
Okay.
charges. I believe this is to do with the criminal charges. He uses the word other powers decided on convictions, not just the police.
Can I then invite us to page 25, paragraph 1.7.10, 1.7.10?
Uh-huh.
You conclude at this paragraph thus, and I quote, given General Mkwanazi's own collusion in an illegal process of political interference designed to keep Ndluli in charge of the Division of Crime Intelligence and its regularly stolen secret funds, it is difficult to take seriously his complaints of political interference.
Yep.
Okay, and you go on. Do I understand you correctly that you suggest General Mkwanazi colluded in retaining General Ndluli in the Division of Crime Intelligence to facilitate the stealing of secret funds? Is that, am I understanding you correctly, or I'm misunderstanding you wholly?
Sorry, I'm not quite...
I was saying my interpretation of what you say there, I wanted to test whether I'm correct or whether I'm misunderstanding
So
you.
what I'm saying is there's similarities.
Yes.
The similarities in 2012 are the same as the similarities in 2025 in July. In 2012, it was to protect the head of crime intelligence, which was Lieutenant General Mdluli. In 2025 in July, it's to protect, I'm saying, and that'll be the next bit that I come on to, that it was to protect crime intelligence.
Oh, so
Those are the similarities.
so a protection of General Mkwanazi, General Mdluli.
Mdluli, I'm
In
saying...
2012, you say was by General Mkwanazi himself.
Yes, I'm saying that in 2011/12, he was protecting one general in crime intelligence. And in 2025, he's protecting 5 generals in crime intelligence.
Okay. Now, you have tendered this affidavit, so I'm sure you are familiar to some extent with it. From paragraph 9 of that affidavit, General Mkwanazi makes the distinction or seeks to.
Sorry, what page?
Paragraph 9, I'll tell you the exact page now. 349, under the heading the Mdluli matter.
So, this is one of the annexes.
Yeah, your annexures, yes. We are still with
Page-
the 349.
Page 349.
349, yes.
Yep, got it.
And at paragraph 8, he makes the point that when he was appointed, General Mdluli was the Divisional Commissioner of Crime Intelligence.
Yep.
At 9, he points out that by then he had, as he joined as an acting National Commissioner, General Mdluli had already been on suspension, having been suspended on 29th April 2021.
Correct.
And that suspension related to the alleged murder case.
Uh-huh.
And at 350, he continues that at paragraph 10, on establishing that Lieutenant General Mdluli had not been suspended on the fraud and corruption charges, which he introduces in the paragraph above, he instructed Lieutenant General Stander, the Deputy National Commissioner of Human Resources, to initiate steps to implement disciplinary charges against Lieutenant Mdluli in this regard. Then at paragraph 11, he speaks about General Nebeam, which we can skip. And then at paragraph 12, he says, as part of my briefing on this matter, I was advised that Major General Solil Lazarus, the Chief Financial Officer of the Secret Service account of CI, had already been suspended and charged criminally for fraud and corruption. He continues at 13, I then decided to instruct Lieutenant General Stander to appoint an outside person to assess the available evidence to determine whether it implicated General Mdluli and then to advise me on the way forward. These events took place roughly towards the end of 2011. I attached marked NM1 a copy of the report obtained by Lieutenant General Stander pursuant to my instructions. He then says at paragraph 15, pursuant to this report, disciplinary charges were brought against Lieutenant General Mdluli. This is now for the fraud. Do you accept the facts as set out by General Mkwanazi in this affidavit, or do you have reason to doubt their veracity?
I can't contradict them.
Okay, now in light of that, if you then are forced to accept, is it fair to suggest that he took steps and colluded in a process that will protect General Mdluli and enable the further looting of secret funds? Is that a fair conclusion? If you accept the facts as stated here.
If what he says here is true, then it means he's doing his job. But then along came the minister who said, cut all this up, drop the charges, put him back to work, and he did that. So he may have started off on that course. I guess the best person to ask is him.
Can I
Yes,
ask a question, because you introduced the involvement of the minister?
Sorry?
You introduced the involvement of the minister.
Yes.
2 months after the suspension was lifted, so on the same day that FUL launched the urgent application, you are aware that General Mkwanazi did suspend General Mdluli again?
10 days later. The Freedom Under Law case was launched
Yes.
on the 15th of May.
Yes.
General Mkwanazi General Mkwanazi resuspended General Mdluli on the 25th of May.
Yeah, don't confuse the date when he was charged with the date when he was suspended. I had understood, having read the judgment, both the High Court judgment and the
No,
Supreme Court of Appeal judgment.
he was resuspended on the
yeah.
25th of May.
I'm looking at paragraph 95 of the judgment. You may be right, because it says the application was launched on the 15th of May 2013. I think that's a typo in the judgment. It's 2012, right?
So
I'm
just-
on page 409.
409.
Yeah.
Let me just go to it.
409.
Yep.
I think this may be a typo in the judgment. That should be 2012, right?
The wording of the paragraph would suggest so.
Yeah.
Which
So,
paragraph, sorry?
Paragraph 95.
95.
Yes.
Uh-huh.
You may be correct. So I think there's a typo there with the date. But your point is that he only resuspended him after the urgent application was launched.
After the Freedom Under Law application was launched, he realized, there's trouble coming.
Yeah.
But contemporaneous with the launching of the Freedom Under Law application, Advocate Chowki was the Director of Public Prosecutions in Johannesburg, and he had given instructions for an inquest into the murder of, or the death of Opa Ramakgobi. So what happened was, during that inquest, in the week after the Freedom Under Law application was launched, and while General Mkwanazi was having to deal with his answering affidavit, revelations were coming out at the inquest about the conduct and the kidnapping and the beating up of Opa Ramakgobi, allegedly by, in fact, he was convicted by it later.
Mr. O'Sullivan, I want to stick to the theme of the question by Advocate Sillo. So my question in essence is, what do you make then of the fact that during the May period he did suspend General Mdluli again, and in fact he was charged?
Well, he didn't really have much of a choice, because he's got this application landed on his desk on the 15th of May.
Yes.
So 10 days later, while he's doing his affidavit to respond to this application, this urgent application, he resuspends him. And I'm saying he was in a corner. He had no choice. He had to do it.
All right.
But
Mr. O'Sullivan, I think you are aware in this affidavit here, you've got where he describes.
Where what?
Where he describes the steps that he took, and
Yep.
that includes engagement with the Inspector General, and the Inspector General at some point instructing that he should lift the suspension and have
Yep.
Mr.
Yep.
Mdluli come back to work,
Yep.
and he didn't agree with that. So you're aware of the steps that he took,
Yep.
but for that he acted on ultimately he acts because the minister is now involved in the matter. You surely couldn't fairly say, disregard everything else that he has done and say, because he followed the minister's instruction and put it as high as that was action, he acted to protect Mdluli who, for purpose of plundering the secret fund. You can't. I mean, there's a logic in it. There's a disconnect in that you seem to, in fact, not you seem to, you do as a matter, as you testify there, you disregard all the efforts that he took to discipline General Mdluli. You disregard that, and then you say, well, he followed the minister's instruction ultimately. The minister instructed him, and by following the minister's instruction, he therefore was in fact protecting Mdluli to enable him to continue to plunder the secret fund. I don't understand that logic or that reasoning, because it seems to be quite selective. From where I'm sitting, you seem to be selective in refusing to acknowledge the steps that he took, but also to acknowledge that, in fact, when he did withdraw the action of the minister, you can criticize him for following the minister, just like the court did, right? That he's got the discretion, he's got the power. He should have insisted to exercise his power. Well, he didn't. He followed the minister's instruction. How that translates so easily, in your view, to it being a deliberate decision on his part to protect crime intelligence general for purpose of plundering the secret fund, and then you say in exactly the same way that is done in 2025. I'm battling to see the connect that you seek to make in what seems to be disconnected.
I don't consider that I've disconnected. If I look at it, what happened at the time? He's only given his version of events 8 years later. Nowhere at the time does he explain all these events. He waits 8 years. He could have said in his answering affidavit to the court, he could have outlined these things then. He didn't. He kept quiet about it. He only comes out with it 8 years later. Now, if one has to give some real thought to this and think out of the box, one has to consider the following. He was a senior police official. He was a major general in the police, and he was aged 38. There were probably at least 40 generals in the police.
So, Mr. O'Sullivan, we're not discussing that now, sorry.
Okay.
It's late in the day. We are
All
not
right.
discussing what you have addressed in your statement. Our question is really, the theme now is a very, it's a direct theme. It doesn't require you to speak about his promotion that you obviously were not happy about. It is simply this, that unless you say everything that he says I did, or the steps that he took to discipline, to suspend, unless you say all of that is a lie, right? And I didn't understand you to be saying all of that which he says he did is a lie. Unless you're saying that it's a lie, I don't see how you can fairly say today, knowing what you know. Remember when you draft this affidavit for the commission, you know this history, what he alleges he has done. Knowing all of that, and then you in June, as we sit here, you say, well, that he did not say it's the minister that instructed him, that he did not contradict General Pierre in an affidavit in court. Those two things are evidence that he in fact was colluding. He made the decision to collude to keep General Mdluli in place so that he can continue to plunder the secret fund in the same way that he's doing in 2025. I don't see how you get there. It seems forced to say, well, that's what he was doing in 2015 or whatever year it is.
Yep.
And then you say, well, it repeats, in fact, in 25.
I hear what you're
it
saying,
seems to be
Commissioner,
forced.
and my point is quite simple.
Yes.
But if the content of his affidavit in 2020 had been included in the content of his affidavit in 2012, I would absolutely agree with you. But it wasn't. The whole thing was kept quiet for 8 years. And I believe, it could have been put out into the open 8 years earlier. And who knows what effect it would have had on the police. It might have changed the future.
Thank you.
I think we've traversed this already, but we did clarify that the freedom under law application was brought in two parts. The part A was an urgent interdict. Is my recollection correct?
Correct.
That is the part A.
Part A, the order was granted.
Yes, I'm aware.
Yeah.
My issue is General Mkwanazi deposed to an affidavit in regard to the relief sought in part A. So it's not the main application. The main application is in part B. The review application,
Yeah,
right?
I agree 100%. The main application was part B.
Yes, so if we agree on that score, are you suggesting that all these facts that he has set out in the affidavit deposed to before the State Capture Commission, he should have set them out in his answering affidavit to the Part A relief?
Because
Is
the central theme of Freedom Under Law's application was his alleged receipt of instructions from a higher authority. And on that, he kept quiet. So I'm saying that would have been and by the way, he didn't have to go into all the detail he's gone into with the Sondo Commission, but what he could have done was take those crisp elements and say, listen here, this is what happened. It wasn't just me, it was the OIG and it was the minister, and then put it on the table. But no, the whole thing was hushed up for 8 years.
Just then, I guess as a final point on this, page 367, we're still in the affidavit, paragraph 24. He states in that paragraph that during this period, of course, this is after a whole long narrative about what was happening and the IGI's report and what steps he took. So then he says, during this period, I met with Lieutenant General Mdluli. I informed him that I had written to the IGI and had received a response from her regarding the disciplinary matter against him, but was awaiting her response regarding the criminal case against him. Yeah. I gave the same advice to Minister Mtetwa. At paragraph 25, he notes, I disagreed with the IGI's view that Lieutenant General Mdluli should return to work. She had not yet read the criminal case docket or expressed an opinion thereon, and I felt that she ought first to do so before he could be reinstated. I telephoned Advocate Khadebe to inform her that I would not be lifting General Mdluli's suspension until she has perused the criminal case docket, as this might influence her initial decision regarding the disciplinary matter against him. I was also aware that Advocate J. Govender from IGI was an experienced advocate and a former prosecutor, so I had faith that she would assist the IGI in making an informed decision on the status of the criminal case. Now, I was just concluding this conversation we're having, that these are some of the steps he states he took to resist the upliftment of General Mdluli's suspension. Yep. Now, my question is, do you take issue with the veracity of what he claims here?
The only issue I take with this is what I said earlier. This belonged in his answering affidavit.
Okay.
He
Not
should
so
have
much
taken the
that-
court into his confidence and explained to the court exactly what went on and then it would have resolved not only Part A, but there would have been no need for a Part B, because actually Part B was fought hammer, tooth and nail by the police, and it was fought out in the Supreme Court of Appeal. So there would have been no need for all of that if he'd have taken the court into his confidence in May 2012.
Noted, thank you.
Advocate Sello, Mr. O'Sullivan, I understand your criticism, and if one reads the SCA judgment, it appears to be the same criticism that one finds at page 470. 470 of the annexures or exhibits. So if you start at 469, paragraph 49, the court says the factual basis for the challenge by FUL is that it relied on statements made by then Acting Commissioner General Mkwanazi in Parliament that he was instructed by authorities beyond him to withdraw the disciplinary charges and reinstate Mhluli in his office. And then FUL added that in doing so, Mkwanazi had failed to make an independent decision which rendered his actions reviewable. So that was the point about the review.
Yep.
And then the court says, this is now SCA, though Mkwanazi filed an answering affidavit in the interim interdict proceedings in Part A of the notice of motion, he did not deal with these allegations.
Exactly
so this
the
is
point.
your point.
Yep,
And
exactly
then
the point.
what the court then concludes, we can ignore the rest of that because it relates to General Pierre. In paragraph 50, the second last sentence, the court says, let's start at the fifth line where the court says, I do not believe this finding can be faulted. Moreover, after all is said and done, neither Mkwanazi nor Pierre gave any reasons for the impugned decision. And then the inevitable conclusion is that the decisions were either dictated to by Mkwanazi or were taken for no reason at all.
Yep.
And so the court has made a decision that in the absence of an explanation, we can conclude that they were dictated to by somebody
Yes,
else.
and Commissioner, if I can say, what they've done in the Supreme Court of Appeal is they've stuck the evidence of Pieka because she stated under oath that this is actually what really happened. And to prove it, I'm going to come with a confirmatory affidavit from General Mkwanazi. And since there was no confirmatory affidavits, they struck that evidence. They said that's immaterial. Therefore, they go back to game one, which was the answering affidavit submitted by General Mkwanazi, where he just didn't deal with the issue.
So the point I'm making is because we were not getting anywhere, and I had understood that your criticism, you were taking it from the judgment. Although you added your own flavor to it, I must point that out, that you
Yes.
added your own flavor to it. But the substance of what the SCA found is that because he did not answer the specific allegations
Yep.
made by FUL,
Yep.
the inevitable conclusion is that he was dictated to
Correct.
by those
Correct.
above him.
Yep.
And we leave it there. And I think when General Mkwanazi comes here the second time, we may then give him the opportunity to respond to
Yep.
your criticism of his conduct. And that's the best way of dealing with it.
I agree.
Thank you, Commissioner Kumalo. You conclude then at paragraph 1.7.10 at page 25 by stating, for example, in 2011-2012, General Mkwanazi's conduct was intended to unlawfully protect Crime Intelligence Divisional Head, much the same as his conduct in 2025 is intended to protect the Criminal Intelligence Divisional Head and those under him. That then leads you to your next topic at page 26. At paragraph 1.8, and I think we should make a correction there. It reads July 2026 media conference. It should be 2025. The heading,
Yes,
we correct the-
1.8.2.
at 1.8, the main heading, it reads July 2026 media conference. That should read July 2025.
Yes, yes, thank you.
Then you say, in this part of your statement, you are more or less posing a question to the commissioners.
Correct.
And you are not testifying or advancing any factual basis
Yeah.
or suggesting that the media conference was intended to protect criminals. That's not your suggestion.
I'm not. It's,
You are posing a question?
It's not a statement, it's
Yes.
a question.
Okay.
And what I'm asking the commissioners to do is to have an open mind and ask yourselves the question, was that media conference a smokescreen? That's what I'm asking you to do. And in order to guide your thinking on that. I've given my own ideas here. And my ideas are quite simple. I've made it clear that for years and years and years, the epicenter of crime in the police service is the Crime Intelligence Division. It's the epicenter. Everything that goes wrong in the police, it's the Crime Intelligence Division. And why? Because we have a so-called secret services account, which is so secret, nobody can know how the money's spent, which is great. Because if you want some money to do other things with, you can do it. And nobody can ask you any questions. No Auditor General has ever given a clean report on the Crime Intelligence Secret Service account. And if one looks at the growth of that fund, by the way, you can pick up from the police budgets the fund itself, but you can't see how it's spent. And in 2012, when General Mkwanazi was the acting Commissioner of Police, the budget for the Secret Service account was 98 million rand per annum. In 2024, it stood at 600 million rand per annum, which is an increase of 512%, which is 5 times the rate of inflation over that same period. But what we don't have is we don't have a concomitant decrease in crime. What we do have, if you look at the last 14 years, is we have successive heads of crime intelligence being arrested and sent to jail for stealing from the Secret Service account. It's just a manna from heaven. It's gift, and there needs to be a lot of control, much better control over that. And I talk about here, when I ask the question, was it a smoke screen? I ask the question, I name 5 generals and 2 brigadiers who were arrested in June 2025. They were arrested on the 26th of June. It's no coincidence. In my annexes, I have taken that media briefing of General Mkwanazi, and I've had it transcribed. The transcription is there. And if you look at the theme of the transcription and start looking at the mentioning of crime intelligence, it starts to conjure in your mind, was this a whole smokescreen to protect all of these people in crime intelligence? And when you think about it, and I ask you to keep an open mind, if you look at it, there has to be an answer there somewhere. It cannot be right that this is all linked. By the way, on the 1st of July, I had my attorneys, the attorneys of Forensics for Justice, I had them send a very strong letter to Commissioner Masemola. And the letter is very strongly worded. And it talks about the accused persons, which I refer to in my affidavit as the Crime Intelligence 7. And in that letter, we're demanding that these people are urgently suspended because they've all been charged with corruption. And according to General Mkwanazi, it's not corruption, it's an HR matter. I don't agree with that. It's corruption. So we have this situation where they're charged with corruption. We send a letter through demanding that they be suspended. An hour later, or 2 hours later, we get a short reply back from General Masemola, which is on page 505 of my evidence bundle, which effectively says, I'll do what has to be done. I'll comply with the law. Not one of them has been suspended. Not one. To this very day, not one of them has been suspended. And by the way, some of them have been charged more than once, because General Lushaba, who's the CFO, he's in charge of the Secret Service account. He was also charged with losing his laptop computer and a firearm, and hiring not hiring, but instructing members under his command to go out and get his laptop and firearm back, and then to doctor the docket that he opened. And when he opened the docket, he said that somebody came in through his window and stole his firearm, his state-issued firearm, and they stole his laptop. But it actually turned out that he'd invited a lady into his premises, and they had a few drinks, and he fell asleep. And she made off with his money, his firearm, and his laptop. He got other police officials at the rank of colonel to go and get his laptop and firearm back, which they did. He's charged for that. He was arrested for it and charged. And what they did, they went and got his laptop and firearm back. But now we had a problem because he'd opened the docket at the police station where he said somebody had climbed in through his open window. So he got those two colonels to go to that police station and get hold of the investigating officer on the case that he'd opened and remove the papers from that docket and replace them with fake papers. So that's the sort of thing that's going on in crime. That's the chief finance officer of crime intelligence. And when you look at all these things going on, and then you analyze, commissioners, the transcription, because nobody's produced the transcription before now. I've produced it. I had it produced within days of his media conference, and it's there at pages 510 to 536. And what's interesting is on page 533. On page 533, he doesn't mention my name. General Mkwanazi says the following: that's why there's a call in public from a person that I will not necessarily mention his name, that the National Commissioner must bypass the disciplinary regulations of the service, must simply suspend these people because it's inaudible. Why is that call? It's a call that is putting more pressure to make sure the country, hence the handing over to the criminal syndicate. So because I've called for the suspension of these 5 generals and 2 brigadiers, General Mkwanazi is accusing me of handing the country over to a crime syndicate. In fact, I'm trying to stop this crime syndicate that's active in crime intelligence from carrying on with their crimes.
Mr. Sullivan, can I ask you one question? You say the press conference of 6 July 2025 was a smokescreen.
Was it? It's a question.
Yeah. So let's assume that it was.
Pardon me?
I'm saying let's assume for the purposes of my engagement with you that it was a smokescreen.
Yeah.
Does it mean that the allegations made that day are not true and should not be investigated? Because that's what this commission has been established to do.
Absolutely.
It is to investigate, amongst others, the allegations that were made by General Mkwanazi on the day. Now, say his motive, for argument's sake, say his motive was to protect the Crime Intelligence 7.
Yeah.
And that was his reason for this press conference. Does that mean the allegations he made are not true and should not be investigated?
Absolutely not. In fact, if you look at me having gone on record, on the 6th of July in the evening, I did a media call. The media contacted me about this whole media conference of his. And the first thing I said was there needs to be a judicial commission of inquiry. I made the point, and I've repeatedly made the point, that the lack of attention by the State Capture Commission to the criminal justice system has resulted in where we are today. And I have absolutely no doubt that a lot of good will come out of the allegations he's made. But were they made for the right reason? That's the question I'm asking. And I don't believe they were. And if you look at the transcript, it starts to come out what actually the purpose of that media conference was. And I don't believe it was just about Minister Mchunu and these various parties, what's his name, Kat Malala, and all these other people. I don't believe it was about that. And the reason I've given in my briefing here today is that I start off by saying, this isn't the first time that we've had criminals penetrating the criminal justice system. It's been going on for years and years. Even during apartheid, it was still going on. So this is not new. But if any good comes out of it, fabulous. But what I'm saying is we need to keep an open mind as to the motive. And that's all I'm requesting.
Is the motive a question that's within our remit, though?
Is the motive, sorry?
Is it a question that's within our remit? Must we answer that question?
If one
Is-
looks
it
at
does-
your,
it
if,
does-
you, if
does-
you look at your,
So does that question fall within our terms of
yes,
reference?
if you look at your terms of reference,
Yes.
it doesn't go there. However, if you apply, as your colleague did earlier, this novus actus interveniens, what if he didn't call that media conference? Would we be sitting here today? The answer is no. So a sequence of events has taken place, and all I'm saying is not everything is what it's been painted out to be. And I've requested the commissioners to keep an open mind. I keep an open mind on these issues. Of course, I would like to persuade you this way or that way, but the reality is I would never like to persuade you of something that's not right.
We should keep an open mind on matters that fall within our terms of reference.
Exactly.
So that's why I'm engaging you on whether this is something that falls within
Well,
the terms
then
of
you're left
reference.
with the question.
You, especially bear in mind that you have said a lot of good has come out of this process, and probably most of it does indeed fall within our terms of reference. So the issue is, all of that, or all of those issues, because we are yet to submit a final report, all of the issues that have arisen are issues that we must keep an open mind on, except those perhaps that are clear and on which everybody has already said something. That is, even those that are implicated.
No, of course.
Perhaps on those we may make, or rather have sort of final views on such matters, but otherwise we keep an open mind. But that relates to matters that fall within our terms of reference. So you keep saying, you're asking us to keep an open mind. If what you are raising, insofar as the motive is concerned, does not fall within the terms of reference, the issue of us keeping an open mind does not arise at all.
No.
If you accept that the question of the motive does not fall within our terms of reference. But I'm engaging you on whether it does, and I think you've accepted that it does not.
It's chicken and egg, isn't it? Because if the motive was to create a smoke screen, then it possibly does fall within your terms of reference, because you need to know what was that smoke screen all about. And then you start asking other questions. So I prefer myself to be the bringer of information, not the decider of facts. But I brought the information to this commission because I've spent the last 36 years of my life trying to make this a better country to live in for all people in South Africa. And that's why when I saw what was going on, I thought, I need to throw my 10 cents into the mixture as well, especially since I've been named by the protagonist. When General Mkwanazi got up and blamed me, I had nothing to do with this Kat Malala and these drug cartels and all the rest of it. I had no knowledge of what was going on until I heard about it in the media. But for him to name me Why was he naming me? And I can tell you the reason why. Because I didn't write, I got my attorneys to write a letter to General Masemola and demand that these 5 generals and 2 brigadiers be suspended. That's why I was named.
I would understand the smoke screen point better.
Brigadiers be suspended. That's why I was named.
I would understand the smoke screen point better if it does not go beyond saying. This was a smoke screen that was calculated to shield these generals from criminality that they are otherwise involved in. So we don't really get into, was it indeed a smoke screen? That's not before us.
I understand.
That's not before us.
I agree with you. I agree with you that your terms of reference do not ask you to consider whether it was a smoke screen.
Yeah. So the criminality itself would then have to be something that does indeed fall within our terms of reference. The criminality shielded by the smoke screen. Your comment?
I suppose the acid test will come in time when we see what happens, because we do know.
Yes. Alleged criminality, of course,
yes,
at this
alleged
stage.
criminality.
Yes,
we do know, for example, that last week or the week before, there were allegedly other warrants of arrest for 2 of the same generals, of 2 of the same 5 generals apparently are going to be arrested again. I have no knowledge of that, only what I've seen in the media. Hopefully tomorrow will be a peaceful day, and then whatever has to happen will happen. But I do believe that it will all unravel. It normally does. You know, if one looks at the late Commissioner Jackie Celebi, people don't believe me when I tell them, actually, I spent 8 years investigating that matter. And they say, 8 years? How can you spend 8 years? Well, you want to get to the truth, so that's what you do. And in this matter, there's a lot of things coming out of this commission, which is really, really good, because we're seeing generals in the police being exposed for criminality. And that's fantastic. But it doesn't mean the person that's exposing them hasn't been involved in any hanky-panky either.
Thank you, thank you.
Thank you, Chair. Just to clarify 2 things. From your paragraph 1.8.2, you deal with this...
Sorry, page number?
26 of your statement. The second paragraph, that's where you introduce the charges brought against Lieutenant General Khumalo and the 6 other members of the service, whom you term the Crime Intelligence 7, right? At the next paragraph, you state that their charges relate to the irregular employment of Ms. Mkwele in a senior ranking position of brigadier in the technical support services of crime intelligence. And then beyond that, you talk about what transpires after they were arrested. The point I want to clarify is the budget and the looting of the Crime Intelligence Fund, alleged, this case has got nothing to do with that. It has no bearing, or in any manner are there allegations that these 7...
This commission?
No, the charges brought against the people you term the Crime Intelligence 7. It's got nothing to do with the looting of the...
For what they were arrested on that day, I agree.
Yes, that's a clarification I seek.
General Pelani Lushaba was arrested 3 weeks before that.
Yes.
And that was pertaining to the Crime Intelligence Funds. And I'm just saying...
Now, let's take it a step at a time, right? We're dealing with these charges here.
Yep.
And I ask this because you start that subject by introducing this 512% increase in the budget, and you pose questions as if there is no legitimate basis for that growth in budget, and therefore insinuating that something untoward is going on. You state that in your 181, and then you follow it up with the charges. So I'm saying, in truth, there is no link between the charges of 26 June 2025 and the so-called looting of the crime intelligence funds? Is it, there isn't?
The only link would be that the people in charge of the crime intelligence fund are the same people that are being charged here.
But these people, you say at 1.8.3 that their charges relate to the irregular
Yes,
appointment
but
of Ms. Mkwanazi, and that's as narrow as it gets.
Absolutely,
Yes.
but as a separate issue, if they can be charged with these acts of corruption, why would you leave them in charge of a 600 million rand budget?
Okay, I will pose that question to SAPS,
Of
but in the
course, I
meantime,
understand.
then you introduce the second issue of General Lushaba, the second charge where you talk about the computer disappearing under.
May I just very quickly ask a question around the appointment of General Mukwele, Brigadier, I'm very sorry, Dineo Mukwele. Sotho people must please forgive me. I'm not at all sure of the pronunciation of this name. The evidence that was given by General Kumalo is that the position required someone with expert skills. I forget the term he used for this, but he had a special term for the expertise they required for this position. And if I'm not mistaken, I think he said largely that expertise is to be found within motor vehicle manufacturers.
BMW.
Sorry?
So when I found out about this,
I did not get the impression that it was BMW only. The skill is within motor manufacturers.
right, she was working at BMW head office.
That may be so, but what I'm saying is, what General Kumalo said was that for this position, they required a certain expertise, and that this expertise is to be found within the motor manufacturing industry. Doesn't have to be BMW, it may be BMW, it may be Toyota, it may be Mercedes-Benz, or whatever other company that manufactures motor vehicles. You are with me thus far?
I understand what you're saying.
Yes. And so he said, it's not unheard of within SAPS to appoint someone who has no experience at all in policing. If that person is being appointed for the expertise they possess, and this applies over several types of industries or environments. So it's not just the motor manufacturing industry. And he gave a few examples. And I'm sure that you too, with the experience that you have, you must be aware that there are other people with other forms of expertise who have been appointed by SAPS and not given the rank of constable, but given higher up ranks within SAPS with no policing experience at all. Do you accept that this does happen within SAPS?
I accept that in the police service,
Yes.
from time to time,
Yes.
people are appointed that have no policing experience.
Yes.
However, they go through a procedure to motivate why that person should be appointed, and there's normally a panel where people are interviewed. It's not my function other than to suggest to the commissioners that the best people to answer these questions would be IDAC, because they're the ones that charge them. And I've seen the charge sheet because it's a matter of public record. And the charge sheet makes it clear that they interfered with the recruitment process to unlawfully appoint this particular woman, when in fact they could have, if she was that important to be appointed, they could have motivated it properly and done it transparently, but it was done without transparency and it was done behind closed doors, and there was no proper recruitment procedure followed, which is why General Mkwanazi said, oh, it's an HR matter. It's not an HR matter. They are alleged to have committed fraud when they hired this lady, and I think IDAC would be best placed to explain why they were arrested and charged rather than myself.
On this having been done behind closed doors, do you mean that there was no advertisement for the position?
That's not what I believe. I don't know. I don't know enough detail about it, Commissioner. All I know is what I saw, I phoned the lady, this Brigadier Makwela, and I explained to her that I'm from Forensics for Justice. I'm speaking to you now because these allegations have been made. I'd like to get your version of events. This is before I made a formal complaint.
But you are basically saying you cannot say that there was no advertisement.
That's what my understanding is, that they didn't follow the correct procedures.
Do you know for a fact whether or not there was an advertisement?
Whether there was what?
Whether there was or there wasn't an advertisement for the position. Do you know?
I don't know. I couldn't find the advertisement.
Or do you know or do you not know, or you say you did not find the advertisement? My next question was going to be, do you know or do you not know what the requirements were for the position?
Absolutely not. I laid the complaint based on the information I had. And what I asked, but by the way, I don't believe I was the only person that laid a complaint. I believe a member of parliament also laid a complaint. The reality of the situation is that the best place to get the answers to these questions, Commissioner, would be IDAC, not me.
You see, what we got, I'm not even sure from what sources, appeared to be the unsubstantiated complaint that someone with no policing experience had been appointed as a brigadier. That doesn't say much. If we know, as you accept, that within SAPS they can appoint someone with no policing experience to a high-ranking position. So that means nothing on its own.
So, Commissioner, I didn't base my complaint on the fact that this person had no policing experience. My complaint was based on the information that I received. And when I checked it out,
Which was what? What was this information?
The information I received was that she was parachuted in, which is an expression meaning bypass all the procedures, appoint her at any costs. That's the information that I received. And that's the report I made.
Do you have any difficulties telling us who or how you received this information?
Pardon me?
Do you have any problems telling us how and from whom you received this information?
So, as I mentioned earlier, Forensics for Justice have a hotline, and we have a web report where you can make a report on the internet without leaving your name, who you are, and you can phone and leave a message on the toll-free number.
Yes.
In this particular matter, it came through on the toll-free number by a person in crime intelligence. You know, I looked into it. I phoned the lady in question to see if she would give me a reasonable explanation. I do believe I may even have the messages that I sent to her.
No. Just give us the substance of.
Okay. So my phone call was, we've received this complaint. I'd like to hear your version of events. She said, no, I can't talk to you. You must speak to head office. I said, who at head office? And she put the phone down. That's not the conduct of a person that's got nothing to hide. So then I obviously ran background checks on this person. I spoke to BMW Motors, and I was able to establish what she was doing there, and that comprised the report which I gave to the OIG, the Office for Inspector General of Intelligence. So when you make these type of complaints, the place because it's crime intelligence, the place you make the complaint is the OIG. And if they don't do anything about it, you might take it further. But I subsequently heard from the OIG, because I had meetings with them, and they told me that they'd referred the matter to IDAC.
Thank you, thank you.
And if I may just follow up on this question the chair asked, in response to a question the chair had posed to you, you stated that you inquired from BMW what position she held at BMW.
He's an admin clerk.
So BMW advised you that she's an admin clerk?
Correct.
And not that she held the qualification that the chair earlier referenced, they never told you about that?
And when I asked her about her qualification, she didn't want to discuss it with me, so I couldn't really go any further.
Well, I'm sure it's not very surprising because you are a third party wanting to know about her personal affairs, so she's not duty bound exactly to account to you, is she?
But when I explained it to her, Commissioners, I didn't say, by the way, I want to know about your personal affairs. I explained that we had received a tip-off, and the tip-off implicated her, and I would like her to clear the air by explaining what happened, how she was recruited. And she just told me, you have to speak to head office. I said, who at head office? She said, no, that's your business, you must find out. And then she put the phone down.
Okay. Have you ever...
Sorry, just for the record, the expertise that was required here is mechatronics.
Say again?
I'm saying the expertise that was required for this position is something called mechatronics. Just for the record, I'm not asking for a response.
May be the case. And I do believe that the best place to get the answer here would be the prosecutor that charged them.
Yes. And lastly, you are not on record as having suggested that she was a tea lady at BMW. That has been bandied about in public. You are not the source of that claim?
Absolutely not.
Okay.
I was able to ascertain that you, at that time, I'm going back now over a year and a half, at that stage she was 29 years old.
Yes.
So definitely not a teenager.
No. Tea lady.
Oh, I thought you said teenager.
No. Then I'll repose my question then.
No.
Because I say it is bandied about. Let me explain myself.
I definitely made no mention of her being a tea lady.
Okay.
But what you have in this country, well, you have in every country, is you have this thing called social media, which
Yes.
I don't engage in.
Yes.
But you get somebody on social media who says, oh, they appointed a tea lady as a brigadier. But, definitely I'm not the source of such
Okay.
activity.
And that's what I sought to establish. Commissioner, yes. But
Mr. O'Sullivan, I ask only because you say you're one of the people, one of two people, I think, who laid a complaint. Now, in respect of Brigadier Mukwele, what was your complaint about her in particular? I'm not asking about the other.
My complaint was that she had been recruited without going through proper recruitment procedures. The informant that came to us told us that this person had been recruited to a position which other people had applied for and were competent to do, but they had bypassed the procedures.
And, I mean, it being a criminal complaint, you consider
It wasn't
that...
a criminal, my complaint wasn't a criminal complaint.
Oh, I see.
It was a complaint to the OIGI that, and by the way, it sat with other aspects of a broader complaint involving properties that were being purchased and other issues,
Yes.
which I haven't brought to this commission because, it wasn't
No,
part of your terms of reference.
You have answered me. I was interested in understanding what firstly, I thought your complaint against her in particular was that she committed a criminal offense, and I wanted to know if that
No, I
is
never
so.
said
You
she
never.
committed
All
a
right,
criminal
that's fine.
offense.
Thank you.
Can you just clear up, sorry, Advocate Sillo, maybe you may resolve a mystery. Was it you by any chance who slipped the dossier, the investigation dossier, under a certain member of parliament's door?
Which dossier?
You said you conducted the investigation and then you sent a complaint to the Inspectorate General?
Let me be truthful.
Yes.
I'm not in the business of jumping on a plane and flying to Cape Town to slide a dossier under anybody's door. The information, I've still got the emails on my email system where I report to the OIGI. I don't send any dossiers to, and I know who you're talking about. I don't do that.
So he did not get it from you?
Absolutely did not get any dossier from me.
Thank you.
Thank you, Commissioner Khumalo. If I may move then to page 28 of your statement,
Yep.
and maybe some clarification here. At paragraph 1.8.9,
Sorry, Mr. Lo, maybe before you do that.
absolutely.
Mr. Sullivan, in your paragraph 1.8.5, you refer us to the two letters. That's your attorney's letter to General Masemola and his response. And your further response to him is quite scathing. And I think you've spoken to that. Looking at his response to your attorneys.
No.
Now I'm saying I am looking at.
Say again?
I'm looking at his response to your attorneys,
Yes.
which you find at page 505,
Correct.
and which obviously displeased you. And you are, in page 506, you speak quite very strongly against that letter.
Yes.
Now, the last paragraph would have been in his response at 505, would be what offended you. And I just want to ask, what is wrong? What do you consider to be wrong with this response?
Which paragraph?
The last paragraph in 505, General Masemola's response to you, to your attorneys.
What was the purpose of the trip? What?
Page 505, are you there with me?
Oh, 505.
Yes.
Sorry. .505, yes?
Yes, that's General Masemola responding to your attorneys.
Correct.
Yes, and my question is, what do you fault with this kind of response? I mean, I look at the last paragraph of that letter, and it is standard letter. And no, let me finish. It's a standard response about respect for the Labor Relations Act. And all the applicable relevant prescripts. And my reading of this is he says, we will act and comply with the Labor Relations Act and the labor law prescripts that deal with matters like this. You take offense to that kind of response. And my question to you is, why do you find this an unsatisfactory response?
Because that response, Commissioner, wasn't a standalone document. I had already been engaging with him. There's multiple emails. So unfortunately, you can't just look at the letter that my attorney sent and his response. You have to look at all the prior emails and the information that I had received, and I had requested action by Commissioner Masemola. And if we go back a little bit, and we talk about the evidence I gave you in respect of General Khan, that's just one example of where I'd laid a complaint and he just ignores me. But on this matter, he sent this letter.
Yes.
And you're looking at a situation where 5 generals and 2 brigadiers, there's going to be no suspension. By the way, they were never suspended.
No. Yeah, sorry, maybe let me clarify what I'm asking. Your attorneys write a letter, right? That's the letter at page 502, in which they demand the suspension of these people. There's no reference to anyone else, any other case. There's no Khan, there's nothing to it. There's just these people, the generals and the 2 brigadiers. And then they demand in the letter that these people must be suspended, otherwise you'll bring an urgent application to court. He responds to you and he says, The National Commissioner is aware of his constitutional duties in terms of the SAPS Act, as well as the SA disciplinary regulations. It must be emphasized that this matter is receiving the necessary attention it deserves, and it's a matter that involves the relationship between employer and employee in line with the Labor Relations Act, as well as all the other relevant prescripts. That's what he says. You respond, and you are displeased by it, and you call it a response which you say you describe as an arrogant middle finger response to my attorney's letter of demand. So at this stage, we are speaking about your
Correct.
attorney's letter and his response. That's all we are discussing. And my question is, what do you find wrong and offensive in the manner in which he has responded, which I've just read to you now?
Well, if I put myself in the shoes of a commissioner of police, and I've got 5 generals and 2 brigadiers that have just been arrested and charged with serious crimes, including corruption, I would immediately suspend them. Immediately. It's good for some police officers get immediate suspension when they do wrong. But these 5 generals and these 2 brigadiers, we get this response saying, I'll do what has to be done, I'll comply with the legislation, but actually nothing was done. They've never been suspended.
The nothing was done, they've never been suspended is post this. The nothing was done. You say nothing was done.
Yep.
They were never suspended.
Yep.
That's what you say.
Correct.
But that is after he has written this letter.
Yes.
So he writes to you on the 1st of July and says, that's the position of the law, I'm aware of it. And you, on the 5th of July, you say this response is effectively a middle finger, is to raise a middle finger to your attorney's letter. What I'm asking is, well, maybe let me speak for myself, that I see nothing wrong in his response. It is standard response that says, I will abide with the prescripts. That he later on doesn't suspend them is a different conversation, and I would probably have the same problem as you, that he didn't suspend them after he said, I'm looking at it. But at this point, I'm speaking to the response, and especially because your response to him is quite flowery language.
Yep.
And it's terribly uncharitable response to him. And I'm asking on that basis but what causes you so much offense in this letter that he writes to you?
My response to him was meant to be antagonistic. It was meant to put him under pressure. I realized, because I took legal advice, based on the letter that he'd given, we were ready to bring an urgent application. But based on that letter, damn, we can't bring the urgent application. Now, that letter may look all good and legal and above board, but the reality of the situation, given the seriousness of the crimes for which these people have been arrested, they should have all been suspended. There can be no doubt in my mind. If I was Commissioner of Police, I would have said, sorry guys, you're suspended immediately.
Yeah, except you're not allowed to do that. You see, we have labor laws in this country.
But they do.
No, let me say.
Yeah.
We have labor laws, we have a disciplinary code that regulates processes that lead up to a suspension. So what you say that you would have done, it wouldn't be in accordance with the prescript. Maybe he shouldn't have followed the prescript if that's what you're saying. But what you're saying he should have done is not how it works.
So
how it works is you give the employee an opportunity to make submissions about why they should not be suspended if you're considering to suspend them. And depending on what they say, it depends what they say, because you have to take into account what they say in their submissions, and then you make a decision. Anything other than that is in fact an unfair labor practice, which our law punishes.
Can I respond?
Yes, you may.
So, if we're talking about a work environment, like a company or corporation, or even a government department, I agree with you. But we're talking about people that are supposed to be upholding the law. And there have been multiple occasions where senior police officials have been suspended instantly. And that, what's good for the goose is good for the gander.
And they have been returned to work if a procedure that was followed is not in compliance with their disciplinary
In some
code and the
cases.
law. They have
Some
been returned.
cases, yeah.
All right. The simple point I'm making is that he says to you, I will follow due process. Maybe he meant to defeat your agent application. I don't know about that. I'm looking at the letter and especially your response to it, and I don't understand what would have angered you that much that you speak the way you do in your response to him, including telling him that you will take him down. You've taken 2 commissioners previously down, and you will get him removed. I'm trying to make sense of that kind of response to this letter.
Yeah.
But I've heard you. Thank you.
Thank you, Chair. Just a quick one, Mr. O'Sullivan. We don't have to go there. I can read it for you. I take it that you are aware that during his testimony on the 17th of September, General Mkwanazi, and it's in his statement, paragraphs 8 and 9, indicated as follows: I must emphasize that this briefing was a product of a collective and collaborative efforts of various units within SAPS and the majority of men and women in the service. It is a reflection of the common concerns shared among members of all ranks and a common desire for their resolution to enable these members to serve with honor. At paragraph 9, he says, in presenting the information I shared with the public, I acted both as a member of this collective and the person designated to deliver this collective message. You recall that? Now you hear that.
I can't remember.
Okay, but you've heard what I've just read out to you.
I've heard what you just said, yes.
Now I turn then to page 28, paragraph 1.8.9. My question really, I'm trying to understand what your challenge is at 1.8.9 in the context of what I have just read. You state that in your submission to the ad hoc committee, which was ignored by them, you pointed out that the PowerPoint presentation used by Mkwanazi had metadata which showed it had been created on a SAPS computer, which is emphasis not Mkwanazi's computer. It would be wise for the commission to establish the use of the said computer and who typed and where they typed the presentation to the media. Why must we concern ourselves with that exercise?
Well, I'm not saying you have to concern yourselves with
Okay,
it.
the basis for
I'm
the
suggesting
suggestion.
it would be wise because it may well be that the person that prepared this presentation is not from Mkwanazi's office at all.
But if you look at the picture, you have
That's the metadata.
the metadata, you have reflected it here. It says the creator is SAPS, then a number there. It gives it's a SAPS computer. So in the context of General Mkwanazi saying that he acted as a member of a collective within SAPS,
Yeah.
and somebody to deliver, does it become an issue that the presentation was not created on his own computer, but on another SAPS computer?
It may not be an issue,
Okay.
but until we know who actually prepared that presentation, why not be transparent about it and say, by the way, on such and such a date, I sat down with this person, that person, and we prepared this presentation. All I'm saying is there's an opportunity to have transparency, and it would be wise to do that. But
Yeah,
I can't dictate to the Commission what to do. I'm just making a suggestion.
I guess, we don't overpromise and underdeliver. I'm trying to appreciate the value of that exercise, because at 1.8.10 you say, I believe it is in the public interest for the computer's users' details to be obtained and the person interviewed to establish who instructed him, her, what he, she was instructed, and where and when he, she typed out the presentation. The metadata reflects that this is a SAPS computer. General Mkwanazi says it's a whole lot of us, I was just there as in a representative capacity. Why must the commission go down that rabbit hole to establish what in
I'm not
particular?
saying the commission must go down that
Okay.
road. I'm saying there's an opportunity there to have some transparency and find out who actually put this together.
It's a member of SAPS,
Yeah, but who?
the collective that General Mkwanazi references in his
One
statement.
person typed this, not a collective.
Okay.
It would be useful to know who that was, I think.
Okay.
Surely, Mr. O'Sullivan, you have something that you would like to establish. What is it that you would like to establish for us to even consider that?
Commissioner, if one looks at the media briefing, and if one looks at this presentation, I'm saying the missing information is how that presentation came into being. And if we're talking about a collective, who is that collective? How did we form? How did we come together to make this presentation? That information is not in the public domain. And since this whole...
Surely you have your own theories.
I have my own theory.
You would not otherwise be going down that route.
I have my own theory, Commissioner.
That's why I'm asking you, what exactly do you want us to establish?
You see, there's the problem. I have my theory, but I would prefer if that information was provided without my theory being applied, because it may or may not reveal something interesting. That's all I wanted to say.
It's very uninteresting for us to go that route if we have no idea what we want to establish.
So my theory may not be factual. So if I have a hypothesis which hasn't been proven and I publish it, what am I actually doing? It's like Leonardo da Vinci inventing the airplane. Actually, he did it 400 years before the plane was invented. Now, the reality is I have a theory, but I'm not in the business of publishing an untested theory.
I was not even pushing you down that route, not at all. I just wanted to get an idea of...
I just believe that there's a lack of transparency around how that presentation came to be.
Just to try on the same theme. If your theory, and I'm not saying it's your theory, if your theory is it's General Mkwanazi and Masemola, and let's say Dimpane, I'm just giving you names randomly, what difference does it make to this which you say we should find out? So you can pick any names and say to us that because what it will reveal is A, B, C, D. It's again trying to understand what really is your issue about this.
Let us say that when I asked this question, it links to a previous question I made about keeping an open mind, about the motive to this media conference, because we have to believe that the motive, according to General Mkwanazi, was that, these are the issues and we want to get it out there and I'm going to become a whistleblower and I'm going to fight for my country and I'll die if I have to and what. Very emotional. And I'm surrounded by people with machine guns and balaclavas and whatnot. And I just believe that there could have been other ways of getting the same amount of attention on this matter without necessarily having this whole media briefing and having all the staff, by the way, from the provincial office there. All those people were sitting there on a Sunday afternoon. And by the way, who would have ever thought that I would receive a copy of that PowerPoint presentation? I didn't even know the media briefing was going on until a journalist phoned me and said, this guy this guy's talking about you after the media. I said, what? Who? Which guy? And he told me. And I said, well, what media briefing? Do you have a copy of it? And he sent it to me. So not realizing I could now check, which I do with a forensic tool, I'm able to pull the metadata from that. And I thought, ooh, that's interesting. Now, I'm just saying there's a lack of transparency here, and that transparency may help show the motive behind this whole process that took place. Because it wasn't just a media briefing, it was a lot more than a media briefing. And I just think that whole thing needs to be opened up a little bit. And it's not part of your terms of reference, but I do believe that somewhere along the way, it may come out, okay, this is what happened, this is what caused it, and these are the people that were involved. What if the theory shows that there was a little third force running around, and that's really what's going on here?
Thank you.
Thank you, Commissioner Baloyi. Mr. O'Sullivan, I think if you turn over to page 29, we've covered the issues that are set out at your page 29. So effectively, that would bring us to the conclusion of your testimony and the end of your statement. And to say to commissioners that barring any questions there may be for Mr. O'Sullivan, that would be the testimony of Mr. O'Sullivan.
Mr. O'Sullivan, thank you very much for your testimony, and thank you for enduring the very long day.
It's a pleasure.
You are excused.
Thank you.
Thank you. 9:30 tomorrow?
9:30 tomorrow, Chair. Thank
Let's
you.
adjourn and resume at 9:30 tomorrow.